You got 30 seconds to walk out that door, or I drag you out by whatever I grab first. The man filled the doorframe. 6'3", shoulders like a truck bumper, one steel-toed boot already across the threshold. Behind him, a second officer leaned against the porch rail, arms folded, watching the street like this was a coffee break. 6:14 a.m. The porch light hadn't even clicked on yet. A woman stood 3 feet inside the doorway in a bathrobe, reading glasses pushed up into her hair, a mug of tea still steaming in her left hand. She didn't step back, didn't flinch. She looked at the folded document in his fist, the way a surgeon looks at a crooked suture, not with fear, but with a precise clinical attention that the man holding it was not equipped to recognize. "I need to see the order," she said. He shoved it into her chest. The tea sloshed. A brown stain spread across the paper before she could unfold it. She read it anyway. Her lips moved once, silently, counting something. Not words, but days. Then she folded the paper along its original creases, set her mug on the hallway table behind her, and said, very quietly, "This order is dated 11 days ago. Under this state's Civil Procedure Code, a residential occupant is entitled to 30 calendar days' notice before enforcement of a writ of possession. You're 19 days early." He grabbed her forearm and pulled. The tea mug hit the hardwood floor. Porcelain shattered. She stumbled forward, caught herself on the doorframe, her shoulder wrenching as his grip tightened. He had no idea that the woman he was dragging toward her own front steps had spent 15 years putting people who violated court orders into prison, from the other side of the bench. And he had no idea that the tiny black rectangle clipped to her bathrobe collar, the one he assumed was a button, had been recording since the moment his boot crossed her threshold. If this story satisfies you, please click subscribe and the bell icon to catch part 2 the moment it drops. The neighborhood was called Wisteria Ridge, 4 blocks of post-war bungalows south of the old textile district, the kind of street where everyone knew which dog belonged to which house and whose grandchildren visited on Sundays. The houses were small, most of them under 1,200 square feet, built in 1951 for mill workers who wanted a yard and a carport and not much else. Over the decades, the mills closed, the workers aged, and the houses passed to children and grandchildren who either stayed or rented them out for numbers that wouldn't cover a parking spot downtown. Sharice Redmond had bought hers 7 years ago. Paid cash, every dollar earned, every dollar documented, every dollar run through a title company that confirmed the deed was clean. The house was nothing special. 2 bedrooms, 1 bath, a kitchen with cabinets that stuck in the humidity, a back porch where she sat most evenings with a book and a glass of water, and the particular silence that comes from having earned the right to sit still. She was 53, kept her hair in short twists, wore reading glasses on a beaded chain her niece had made in summer camp. She dressed simply, cotton blouses, flat shoes, cardigans that had outlived 2 presidential administrations. Nothing about her appearance suggested authority, nothing about her manner suggested threat. She moved through the world the way a woman moves when she has learned that visibility itself can be dangerous. Carefully, quietly, with an economy of gesture that most people mistook for timidity. Her neighbors knew her as the woman who kept the tidiest yard on the block, who brought soup to Oralee Pickett across the street when Oralee's hip surgery kept her bedbound for 6 weeks, who sorted her recycling into 4 separate bins and set them out at exactly 7 a.m. every Tuesday, aligned with the curb like soldiers at inspection. Nobody on Wisteria Ridge knew what Sharice Redmond had done for a living before she moved here. She never volunteered it. When asked, she said she'd worked in government, which was true, in the way that saying the ocean contains water is true. It was a fact that revealed nothing. Her mornings followed a ritual so precise it bordered on choreography. Up at 5:15, kettle on, stretch routine, 12 minutes, same sequence, never skipped. Tea brewed at exactly 5:28, black, loose leaf, 1 spoon of honey, stirred counterclockwise out of a habit she no longer remembered forming. Then she sat at the kitchen table with a hardcover notebook, navy blue, unlined, bought in bulk from an office supply store, and wrote, not a journal, not a diary, Observations, dates, times, names. Cross-references to documents she kept in labeled folders inside a fireproof lockbox under her bed. She had been writing in those notebooks for 14 months, and now, standing on her own porch at 6:14 a.m. with a bruise forming on her forearm and tea soaking into an eviction order that shouldn't have existed, she understood that 14 months of patience were about to become necessary. The man who had grabbed her was named Trent Kimball. She knew this because his badge was clipped to his belt and because she had seen his name in the county's civil enforcement roster, a public document she had obtained through a records request 11 months ago. He was 38, former military, transferred from the sheriff's department to civil enforcement 2 years prior. He had a reputation for efficiency. Efficiency in this context meant speed. Speed in this context meant people left their homes before they understood what was happening. The second officer, the one leaning on the porch rail, was younger, thinner, with the uncertain posture of someone who hadn't decided yet whether he was comfortable with what he was watching. His name tag read Prewitt. He hadn't spoken. He hadn't intervened when Kimball grabbed her arm either. "Ma'am, I'm going to need you to step outside the residence," Kimball said. His voice had dropped from threat to procedure, the shift that happens when an enforcer realizes the person isn't screaming or crying and therefore requires a different playbook. "This is a lawful eviction under court order signed by Judge Gault, 14th Judicial District. You have the right to collect personal belongings not to exceed 2 standard containers. Anything remaining after—" He checked his phone. 7 a.m. will be cataloged and held for 30 days at the county storage facility. Sharice looked at the order again. The tea stain had blurred the case number, but she'd already memorized it. "This order references case number 24CV-0817, she said. "I'd like to confirm, was this case adjudicated in open court with proper service of process, or was it entered by default?" Kimball's jaw tightened. He was not accustomed to questions that used words like adjudicated. "Ma'am, I don't interpret court orders. I enforce them. You can take that up with your attorney." "I don't have an attorney. I'm representing myself." Something moved across Kimball's face, a flicker of satisfaction, maybe pity, maybe both. A woman without a lawyer was a woman without defenses. That was how the math worked in his experience. "Then I suggest you get one," he said. 7 a.m. Everything not in a bag goes on the lawn. He turned and walked toward his vehicle, parked at the curb with its hazard lights blinking. Prewitt followed, glancing back once at Sharice with an expression she filed away for later. Not hostility, not sympathy, something closer to discomfort. The discomfort of a man who suspects he is participating in something wrong, but has not yet located the courage to say so. Sharice went inside, closed the door, locked it. Both locks, top and bottom, the way she locked everything, the way she had locked doors for 30 years, with the deliberate attention of someone who understood that locks were not about security, but about documentation. A locked door that was breached was evidence. An unlocked door was an invitation. She did not panic. She did not cry. She picked up the pieces of the broken mug, dropped them into the kitchen trash, wiped the floor with a dishcloth, and sat down at the table with the stained eviction order and her Navy notebook. She wrote, June 14th, 6:14 a.m. Trent Kimball, Civil Enforcement. Physical contact, right forearm. Partner, Prewitt, first name unknown. Order references, 24-CV-0817. Enforcement 19 days premature. Per State Code, Section 735.015. A. Recording device active. Then she opened the eviction order and began reading it line by line, the way she had read 10,000 documents before it. Not for what it said, but for what it got wrong. It got 3 things wrong. The first was the date. The order gave her 15 days from service to vacate. State law required 30. Someone had either miscalculated or, more likely, chosen a number that would ensure the occupant couldn't respond in time. The second was the service method. The order stated that service had been completed by certified mail on June 3rd. Sharice had not received certified mail on June 3rd. She had not received certified mail at all. No signature card existed because no carrier had attempted delivery. She knew this because she kept a daily log of every item that arrived in her mailbox, another habit that most people would find excessive and that she found essential. The third was the plaintiff. The eviction had been filed not by a landlord, Sharice was the owner, but by an entity called Cornerstone Meridian LLC, claiming a lien interest in the property based on an unpaid municipal assessment. Sharice had never heard of Cornerstone Meridian LLC. She had never received a municipal assessment. The property tax records, which she checked quarterly, printed and filed, showed a zero balance. Someone had manufactured a debt, attached it to her home, and used it to generate a court order removing her from property she owned free and clear. She finished her tea, a second cup, brewed while she worked, and opened her laptop. The county court's electronic case management system was publicly accessible, though its search function was unreliable. She typed in the case number from the order. The screen loaded slowly. When it appeared, she leaned forward. The filing date listed in the system was May 29th. The date on the paper order was June 3rd, 5 days difference. The system showed the filing attorney as P. Lathrop, Graymark and Lathrop LLP, and the assigned judge was Harlan Gault. Sharice closed the laptop, opened her lockbox, pulled a folder labeled Graymark, and added the eviction order to a stack of documents that was already 3 inches thick. Then she picked up her phone and made a call. "Ms. Redmond?" The voice on the other end was young, tired, the kind of tired that comes from carrying too many cases on too little sleep. "It's 6:30 in the morning. They came to my house, Calvin." Silence. Then, "How early?" 19 days early. Physical contact during service. I have it recorded." More silence. She could hear him breathing, calculating. "I'll pull the filing," Calvin Trask said. "But Ms. Redmond, I have to be honest. I've got 87 open cases right now and Judge Gault's docket moves fast. If they filed on the 29th and he signed it the same week..." "He signed it the same day, Calvin, May 29th. Filing and order. Same date. No hearing, no notice. Just a signature." The silence this time was longer. That shouldn't be possible." "No," Sharice said. "It shouldn't." She hung up. Got dressed. Navy blouse, gray slacks, flat shoes. No jewelry except a thin watch with a leather band. She packed her notebook, the eviction order, 3 folders from the lockbox, and a printed spreadsheet she had assembled over the past 14 months. 214 entries, color-coded, cross-referenced by address, filing date, plaintiff, assigned judge, and outcome. Every entry was an eviction in the 4th District. Everyone involved a property owner, not a renter. Everyone had been filed by the same firm. Everyone had been signed by the same judge, and 73% of the owners were black. The 14th Judicial District Courthouse was a limestone building from 1938, 3 stories, with a rotunda that echoed so badly that lawyers learned to whisper or be quoted. The metal detectors at the entrance were new, installed after a budget fight that took 4 years and a bomb threat to resolve. The security guard recognized regulars and waved them through. Everyone else emptied their pockets and waited. Sharice was not a regular. She placed her bag on the belt, walked through the detector without triggering it, and collected her things on the other side with the unhurried precision of someone who had passed through 10,000 security checkpoints and understood that rushing invited attention. The clerk's office was on the 2nd floor, room 204, behind a counter with a plexiglass partition that had been installed during the pandemic and never removed. The sign on the wall read, "Filings accepted, 8:30 a.m. to 4 p.m., no exceptions." No, it was 8:41 a.m. Sharice approached the counter. The man behind it was in his mid-50s, silver-haired, with the particular stillness of someone who controlled access and knew it. His desk nameplate read, "Niles Ogden, Senior Clerk." "I'd like to file a motion to vacate an eviction order," Sharice said. She placed her documents on the counter. The motion, typed and formatted, with exhibits attached, tabbed and numbered. Ogden glanced at the papers without touching them. Case number? 24CV-0817. He typed slowly, looked at his screen, then looked at her. This case was resolved by default on May 29th. The window for a motion to vacate closed 14 days after entry of judgment. He paused. That was June 12th, 2 days ago. The 14-day window runs from the date of service, not the date of entry, Sharice said. I was never served. No certified mail was received. No process server appeared at my address. The first notice I received was this morning at 6:14 a.m., when an enforcement officer arrived with a writ of possession 19 days before the statutory enforcement date. Ogden's expression did not change. He had the face of a man who had heard every argument and found none of them compelling. Ma'am, the system shows service completed by certified mail on June 3rd. If you're claiming improper service, you'll need to file an affidavit of non-service along with proof, tracking records, postal verification, that sort of thing. I have those. Sharice placed a second document on the counter. A USPS tracking inquiry printout showing no delivery attempt to her address on June 3rd, or any date within 30 days of it. This is the tracking confirmation for every piece of certified mail sent to my address in the past 90 days. None originated from this court or from Graymark and Lathrop. Ogden looked at the printout, looked at his screen, looked at Sharice. Then he did something that she had been waiting for. He picked up the phone, cupped his hand over the mouthpiece, and spoke to someone she couldn't see. 3 sentences, too low to hear. He hung up. I'll need to consult with the supervising clerk on this filing. Can you take a seat? It may be 20 to 30 minutes. Of course. Sharice collected her documents, sat in one of the plastic chairs against the wall, opened her notebook, and began writing. She wrote, June 14th, 8:43 a.m. Niles Ogden, Senior Clerk. Initial refusal to accept filing. Claimed 14-day window expired, based on entry date, not service date. Consulted by phone after presented with USPS tracking data. Instructed to wait. She waited 47 minutes. At 9:30 a.m., Ogden returned to the counter and called her forward. I can accept the motion, he said, but I need to inform you that Judge Gault's calendar is full through the end of the month. The earliest available hearing date is, he scrolled, July 19th. 35 days away. 35 days during which the eviction order remained active. 35 days during which Trent Kimball could return with reinforcements and a moving truck. Is there an emergency motion procedure? Sharice asked. You can file an emergency stay, but those go through the same calendar. Judge Gault handles all emergency motions for his own cases. The judge who signed the original order also decides whether to pause it? Ogden's face remained neutral. That's standard procedure in this district. Sharice nodded. She did not argue. She did not raise her voice. She signed the filing, paid the $45 fee, receipt number 2024-06-14-0093, and left the clerk's office with a time-stamped copy of her motion in her folder, and 47 minutes of documented delay in her notebook. The hallway outside room 204 was busy at 9:30 on a weekday morning. Lawyers with rolling briefcases, defendants looking for courtroom numbers, a woman with 2 children trying to find the family court division. Sharice moved through the crowd with her head down, not because she was hiding, but because she was thinking. And then someone hit her. Not accidentally, not the kind of bump that happens in a crowded corridor. A shoulder, hard, deliberate from behind, that sent her stumbling sideways into the wall. Her folder hit the floor. Papers scattered. She turned. A woman in a charcoal suit stood 2 feet away, phone in one hand, coffee in the other, looking at Sharice with the particular expression of someone who expects an apology from the person they just collided with. "Watch where you're going," the woman said. Sharice bent down to collect her papers. A page from the spreadsheet had slid under the bench against the wall. She reached for it. A heel came down on it. Black patent leather, 3 inches, polished to a mirror finish. "I said watch where you're going." Sharice looked up. The woman was in her late 40s, blonde highlights precision-streaked through dark hair, a gray mark and Lathrop ID badge clipped to her lapel. Not Paige Lathrop herself. Sharice had studied Lathrop's face in enough Bar Association photos to know, but someone from the firm, an associate maybe, or a paralegal with an attitude borrowed from her boss. "You're standing on my document," Sharice said. The woman looked down as if noticing the paper for the first time. She didn't move her foot. "Maybe don't leave your papers on the floor of a courthouse." She smiled, the kind of smile that has nothing to do with warmth and everything to do with territory. Then she lifted her heel, stepped over the paper, and walked away. Sharice picked up the spreadsheet page. A heel-shaped scuff mark crossed 3 rows of data. She smoothed it flat, slipped it back into the folder, and wrote in her notebook. 9:34 a.m. Graymark Associate. Female. Charcoal suit. Deliberate physical contact in hallway outside room 204. Stepped on document. ID badge visible, but name not readable at distance. She was beginning to understand the geography of this place. Not the building, but the ecosystem. The courthouse was Graymark territory. The clerk deferred. The calendar protected. The hallways enforced a hierarchy that had nothing to do with law and everything to do with familiarity. Sharice was an outsider, and the ecosystem was already producing antibodies. 3 days later, Sharice returned to the courthouse for a different reason. Not to file, to observe. She arrived at 8:15 a.m., early enough to get a seat in the gallery of Courtroom C, where Judge Gault held his civil docket. The courtroom was smaller than she expected. Wood paneling from the 70s, fluorescent lighting that buzzed at a frequency designed to erode patience, 12 rows of bench seating that could hold maybe 60 people if they didn't mind touching shoulders. Gault entered at 9 a.m. sharp. 62 years old, silver hair combed straight back, reading glasses perched on the end of a nose that looked like it had been broken once, and set by someone who didn't care about symmetry. He wore his robes the way some men wear expensive coats, not as a uniform, but as an announcement. He sat, adjusted his microphone, and opened a folder. "First matter," he said. Case 24CV-0712. Cornerstone Meridian LLC versus Oralee Pickett. Sharice's pen stopped. Oralee Pickett, her neighbor, 74 years old. The woman who had lived at 412 Wisteria Ridge for 42 years, raised 3 children in that house, buried a husband from that front porch. The woman who had trouble reading English because she'd grown up speaking Gullah in the Low Country and hadn't finished high school before she came north to work. Oralee was not in the courtroom. "Is the defendant present?" Gault asked. He looked at the gallery the way a man looks at a parking lot, scanning for a specific car, not expecting to find it. No one stood. "Counsel for the plaintiff?" A woman rose from the front bench. Tailored navy suit, leather portfolio, the composed posture of someone who had been in this room so many times that the furniture had adjusted to her. She walked to the podium with the ease of a homeowner crossing her own living room. "Paige Lathrop for Cornerstone Meridian LLC, Your Honor. We're prepared to proceed by default." Gault nodded. "Service confirmed? Certified mail, Your Honor. Tracking shows delivery on May 17th. Gault looked at his file, looked at the empty gallery where Oralee Pickett should have been sitting. Then he picked up his pen. Default judgment entered in favor of the plaintiff. Writ of possession to issue in 15 days. 15 days, not 30. The whole proceeding took 90 seconds. Oralee Pickett, who had never received a certified letter because she didn't check her mail daily, because she was 74 and recovering from hip surgery and relied on a neighbor to bring her mail to the door, and because the neighbor had been on vacation the week the letter supposedly arrived, lost her home in 90 seconds. Paige Lathrop gathered her portfolio. "Thank you, Your Honor. Next matter. This story is just getting started. If you want to see what happens when the truth comes out, hit subscribe now. Part 2 drops soon." Sharice sat in the gallery for 3 hours. She watched Gault process 11 cases. 8 of them involved Cornerstone Meridian LLC. 8 of them were represented by Paige Lathrop. 7 of the 8 defendants were absent. All 7 received default judgments. All 7 were granted writs of possession in 15 days instead of the statutory 30. The one defendant who was present, a man named Langston Bryce, 33, wearing a dress shirt that was too big for him and holding a manila folder that looked like it had been assembled at a library printer, stood at the podium and tried to explain that he had never received notice of the municipal assessment that formed the basis of the eviction. Lathrop interrupted him. "Your Honor, the defendant has failed to file a timely response. The window for contesting the assessment closed 21 days ago. We move for default judgment." Bryce's voice cracked. "I just found out about this last week. Nobody told me. I didn't get any mail. I didn't—" "Mr. Bryce." Gault's voice was not unkind. It was worse than unkind. It was bored. "The court's calendar is based on filing deadlines, not on when parties become aware of proceedings. If you believe service was defective, you may file a motion to vacate within 14 days of today's date. Do you have counsel?" "I can't afford—" The court notes the defendant's response. Default judgment entered. Writ of possession in 15 days. Next matter. Langston Bryce stood at the podium for 3 seconds after the gavel fell, holding his manila folder, looking at the judge with the particular confusion of a man who has just discovered that the system he believed would protect him has been designed, specifically and deliberately, to do the opposite. Then he walked out. Sharice found him in the hallway, sitting on a bench with his folder on his lap and his head in his hands. She sat beside him, not too close, close enough to be present, not close enough to intrude. "How long have you owned your home?" she asked. He looked up. Red eyes. Not from crying, from the strain of holding it in. 3 years. First house I ever bought. Saved for 9 years to make the down payment. He looked at his folder. "They're saying I owe $14,000 in municipal assessments. I've never missed a tax payment. I have every receipt." "Can I see your receipts?" He hesitated. She understood the hesitation. A stranger asking to see your financial documents in a courthouse hallway was either a lawyer or a scam. "I'm not a lawyer," she said. Which was true. She was not licensed in this state, and she was not offering legal advice. She was a homeowner with a similar problem. That was all. He handed her the folder. She opened it with the same deliberate care she gave everything, tab by tab, page by page, comparing dates and amounts to a template she carried in her memory the way other people carry song lyrics. His tax payments were current. Every quarter, paid on time, receipts from the county tax collector's office. The municipal assessment referenced in the eviction filing did not appear in any county record she could find. It was, as far as she could tell, a fabrication, a debt that existed only in the filing and nowhere else. "Mr. Bryce, who told you about the assessment?" "Nobody told me. I got the eviction notice on Friday. That was the first I heard of anything." "And the eviction notice? It came by mail?" "No, a man came to my door. Big guy, military haircut." Sharice's pen paused over her notebook. "Did he give you a name?" "Kimball. He said his name was Kimball." She wrote, "Langston Bryce, 412 B. Oleander Street." Same pattern. Fabricated assessment. Same enforcement officer, Kimball. Same judge. Same firm. Same plaintiff, LLC. "Mr. Bryce, I'm going to give you a phone number. It's for a legal aid attorney named Calvin Trask. He's overworked and underpaid, but he's good, and he knows this court. Tell him Sharice Redmond sent you. Tell him everything you told me." Bryce looked at her. Really looked for the first time. "You're going through the same thing?" "Yes." "Then how are you so calm?" She closed her notebook, considered the question. There were many answers, most of them true, none of them simple. "Because being calm is the only weapon they don't know how to take away from you," she said. That night, Sharice sat on her back porch with her laptop and her spreadsheet and the particular silence of a neighborhood that was being hollowed out from the inside. 3 houses on Wisteria Ridge now stood empty. their owners evicted, their doors padlocked, their yards already beginning the slow decline from maintained to forgotten. Oralee Pickett's house was one of them. The for sale sign had gone up before Oralee's daughter could drive down from Philadelphia to help her appeal. The buyer, according to county transfer records filed 2 days after the eviction, was Cornerstone Meridian LLC. The purchase price was $61,000. Oralee's house, at market value, was worth $190,000. Sharice had mapped this pattern across the entire 4th District. The numbers were not ambiguous. They were not subject to interpretation. They were a blueprint. Step 1. A municipal assessment appears in the court system. No notice to the homeowner, no hearing, no opportunity to contest. Step 2. When the homeowner fails to respond to an assessment they never knew about, Graymark and Lathrop files an eviction on behalf of Cornerstone Meridian LLC, claiming a lien interest. Step 3. Judge Gault signs the order. Same day as filing. No hearing. Default judgment. Step 4. Trent Kimball shows up before dawn with a writ of possession and a timetable that violates the statutory waiting period. Step 5. Cornerstone Meridian buys the property at a fraction of market value. Step 6. The property is rezoned for mixed-use development under a plan championed by Councilwoman Judith Calder's Community Renewal Initiative. The chain was clean. Each link was technically defensible in isolation. A clerk could say the filing was routine. A judge could say the default was procedural. An enforcement officer could say he was following orders. A buyer could say the purchase was at market rate. And technically, it was at market rate if the market was defined as a distress sale where the seller had no representation and no time. But Sharice didn't work in isolation. She worked in patterns. And patterns, she had learned across a career that most people on Wisteria Ridge would never know about, were where the truth lived. Her phone buzzed. A text from Calvin Trask. Bryce called. Same pattern. Judge Gault, same day, signing. How many more? She typed back. At least 214 in 24 months. 157 black homeowners, all 4th District, all Graymark, all Gault. 3 dots appeared. Then, Ms. Redmond, where did you get those numbers? Public records, tax filings, court docket, Secretary of State database, all open source. Another long pause. Then, who are you? She looked at the message for a full minute before typing. Someone who knows how to read a file. She did not elaborate. Not yet. Heck. The emergency stay hearing was scheduled for June 28th, 14 days after her initial filing, which was itself 2 weeks after the eviction attempt. In the interim, the eviction order remained technically active, which meant Trent Kimball could return at any time. He returned on June 21st. This time, he brought help. 6:45 a.m. Sharice was in her kitchen, dressed, notebook open, coffee untouched. She heard the truck before she saw it, a diesel engine, the kind that pulls a flatbed. Through the window she counted, Kimball's enforcement vehicle, a county truck with a trailer, and a white sedan she didn't recognize. Kimball knocked. Not politely. 3 strikes with the flat of his fist, the kind of knock designed to sound like a breach. She opened the door before the 4th strike. Ms. Redmond? His tone had shifted since the first visit. Harder edges. Someone had briefed him. I have a renewed writ of possession, effective as of today. You are required to vacate immediately. Personal items must be removed within 45 minutes. I filed an emergency motion to stay on June 14th, Sharice said. That motion is pending before the court. Enforcement of the writ is subject to... The court has not issued a stay. Until it does, this writ is enforceable. You can argue procedure with the judge. Right now, I need you outside. 2 men in coveralls had already climbed out of the county truck. They were unloading black garbage bags from the trailer. Not boxes, not containers, not the protective materials required by state code for property preservation during eviction enforcement. Garbage bags. Those aren't standard storage containers, Sharice said. State Code 735.020 requires that personal property removed during enforcement be stored in sealed, labeled containers suitable for protection of household goods. Garbage bags don't qualify. Kimball's jaw worked. He looked over his shoulder at the men with the bags, then back at Sharice. Ma'am, we're not packing your china for a move. We're clearing a residence under court order. If you want to pack your own things in whatever containers you prefer, you've got 45 minutes. After that, we pack what's left. And the recording device? Sharice pointed to her collar. You're aware this interaction is being recorded? Something changed in Kimball's posture. Not fear. He was too experienced for fear. But a recalibration. The slight adjustment of a man who realizes that the person he's dealing with has thought 3 moves ahead, and he hasn't thought past 1. Record whatever you want, he said. The order is valid until a judge says otherwise. He stepped past her into the house. What happened next took 11 minutes. Sharice documented every second. Kimball directed the 2 workers through the house with a clipboard, checking rooms. When they reached the bedroom, one of them opened the closet and began pulling clothes off hangers, not folding, not sorting, pulling and dropping them into a black garbage bag. A winter coat, blouses still on their hangers, a box on the top shelf that contained letters from her mother, handwritten, irreplaceable. That box stays, Sharice said from the doorway. The worker looked at Kimball. Kimball shook his head. Everything goes, ma'am. Sharice stepped forward and reached for the box. Kimball's hand closed around her wrist. Not her forearm this time. Her wrist. The grip was tight enough that she felt the bones compress. She didn't pull away, didn't struggle. Instead, she looked directly at his body camera, the one clipped to his vest, the one that was required by department policy to be recording during all enforcement actions. Officer Kimball, you are now touching me for the 2nd time during an enforcement action in which I have been compliant and non-resistant. Your body camera is active. My personal recording device is active. I am asking you to release my wrist. He held on for 3 full seconds. 3 seconds of silence in which the only sound was the worker in the closet stuffing her mother's letters into a garbage bag. Then he let go. She stepped back. Her wrist throbbed. She could already see the marks. 4 finger-shaped impressions turning red against her dark skin. I want it noted, she said, that Officer Kimball made physical contact with a compliant occupant during a property enforcement action. Time, 6:52 a.m. This is the 2nd documented instance of unauthorized physical contact. Kimball didn't respond. He turned to the workers. 45 minutes. Start with the kitchen. Sharice walked to the kitchen table, picked up her notebook, her folders, her laptop, and the fireproof lockbox. She carried them to the front porch and set them down. Then she went back inside and began filling 2 boxes, the only 2 she had, with what she could save. She saved her notebooks, all 14 of them, the folders from the lockbox, her laptop and its charger, 2 changes of clothes, a photograph of her mother, the beaded chain her niece had made. She did not save the rest of her clothes, her kitchen supplies, her books, her furniture, the curtains she'd sewn herself, the garden tools in the shed, or the 42 years of accumulated life that her neighbor Orally Pickett had also been forced to leave behind when Kimball came for her 3 weeks earlier. At 7:28 a.m., Kimball emerged from the house and pulled the door shut behind him. He attached a padlock, county issued, orange, stamped with a case number. Residence is secured, he said into his radio. Subject has vacated, property cataloged and... Not cataloged, Sharice said from the porch where she sat with her boxes. None of my belongings were cataloged. No inventory list was created. No photographs were taken of items removed. State Code 735.025 requires a written inventory signed by the enforcement officer and the occupant. You have not created one, and you have not asked me to sign one. Kimball turned off his radio. Ma'am, you've been told. Take it up with the court. He walked to his vehicle. Prewitt, who had watched the entire 11 minutes from the porch rail without speaking, without intervening, without recording a single note, followed him. Sharice sat on her porch with her 2 boxes and watched them drive away. The morning was bright, humid, the kind of June heat that makes asphalt soft. A cardinal was singing in the magnolia tree at the corner of the lot. She picked up her phone and called Calvin Trask. "They came back," she said. "Physical contact again. Garbage bags instead of containers. No inventory. My belongings are in a county truck heading to a storage facility I haven't been told the address of." "Are you hurt?" She looked at her wrist. The finger marks were darkening. By afternoon they would be a bruise she could photograph and enter into evidence. "I'm fine," she said, "but I need the hearing moved up. The 28th is too late. They'll sell my house before then." "Judge Gault controls the emergency calendar, Ms. Redmond. I can't—" "Then we go above him." Silence. "Above a sitting judge? How?" "File a complaint with the Judicial Conduct Commission. Cite Canon 2, the appearance of impropriety. Attach the pattern data, 214 evictions. Same judge, same firm, same plaintiff. Same-day filing and order. No hearings. 15-day writs instead of 30. And add this." She paused. "I pulled Gault's financial disclosure from the State Ethics Commission website. He's required to list all business interests, investments, and sources of income over $1,000. And he didn't list one. A limited partnership called Meridian Holdings Group. I found it in the Secretary of State's business registry. It was incorporated 14 months ago. The registered agent is a law firm, not Graymark and Lathrop, a different firm. But the filing address is the same as the address listed on Councilwoman Judith Calder's campaign finance reports." She could hear Calvin Trask breathing. "Ms. Redmond, how long have you been— How do you know all this?" "Public records, Calvin. Everything I've told you is sourced from publicly available documents. Tax filings, court dockets, business registrations, campaign finance disclosures, USPS tracking data. None of it is secret. None of it is sealed. It's just that nobody has ever put it all in one place before. That's not— Most people don't know how to— "I know." Another pause. Then Calvin Trask said something she hadn't heard him say in the 3 months she'd known him. "Ms. Redmond, who are you?" She looked at the padlock on her front door. Orange metal, reflecting the morning sun. A color chosen to be visible, to mark a property as seized, to announce to the neighborhood that someone inside had lost. "I'm a homeowner who lost her house this morning," she said. "That's who I am today, and that's enough." She stayed with Oralee Pickett's daughter that night. Marvina, who had driven down from Philadelphia and was renting a one-bedroom apartment near the hospital while she tried to navigate the appeals process for her mother's eviction. Oralee herself was in a nursing facility now. The hip surgery recovery had been going well until the eviction notice arrived. After that, her blood pressure spiked. She fell in the bathroom of the temporary housing, and the fall set the hip recovery back by months. "Mama keeps asking when she can go home," Marvina said. She was sitting at the kitchen table with a laptop and a stack of papers that looked depressingly similar to Sharice's own stack. "I don't know how to tell her that home isn't there anymore." Sharice was reading Marvina's eviction documents. Same template, same language, same filing attorney, P. Lathrop, same judge, Gault, same plaintiff, Cornerstone Meridian LLC, same fictional municipal assessment, same 15-day writ. "Did your mother ever receive notice of the assessment?" "Mama doesn't open mail she can't read. She relies on me, and I was in Philadelphia. By the time I found out, the default had already been entered." "The notice, was it in English only?" "Yes." Sharice wrote, "Oralee Pickett. Limited English proficiency. No translated notice provided. Potential violation of Title VI, Civil Rights Act. Federally funded courts required to provide meaningful language access." She looked up from her notebook. Marvina was watching her with the same expression Langston Bryce had worn, the expression of someone observing a level of competence that doesn't match the bathrobe and flat shoes presentation. "You do this for a living," Marvina said. Not a question. "I used to." "Used to do what?" Sharice closed the notebook. "Government work." Marvina accepted this the way people accept answers they know are incomplete, with a nod and a decision not to push, because the person sitting across the table is the only person who seems to know what's happening, and asking too many questions might make her stop helping. "What do we do now?" Marvina asked. "Now we find the others." Over the next 9 days, Sharice found them. She worked from Marvina's kitchen table, from the public library on 4th Street, from a coffee shop near the courthouse where she could use the Wi-Fi and watch the Graymark and Lathrop associates coming and going through the side entrance. She cross-referenced her spreadsheet against the county recorder's office, the tax assessor's database, and the Secretary of State's business filings. She made phone calls, not to lawyers, not to reporters, not to politicians, to homeowners, to the people whose names appeared in her spreadsheet as defendants in cases they didn't know existed. She found Dinah Falk on day 3. Dinah was 58, a nurse at County General, single, owned a house on Sycamore Lane that she'd bought with a VA loan after 2 tours as a Navy medic. She had been in the hospital for gallbladder surgery when the eviction was filed. The notice had been served by certified mail, according to the court record, while she was under anesthesia. "I came home and the locks were changed," Dinah said. Her voice on the phone was flat, depleted. "Everything I own is in a county warehouse somewhere. They won't tell me which one." "Did you file an appeal?" "I tried. The clerk told me the deadline had passed." "Which clerk?" "Older man, silver hair, room 204. Niles Ogden. Sharice wrote, "Dinah Falk, service during hospitalization." Clerk Ogden denied filing. Same pattern. She found 7 more homeowners over the following week. Each story was a variation on the same theme: a debt they didn't owe, a notice they didn't receive, a deadline that passed before they knew it existed, and a house that was purchased by Cornerstone Meridian LLC within days of the eviction at a fraction of its value. All of them were black. All of them had been in Gault's courtroom, or more precisely, had not been in Gault's courtroom, because the system was designed to ensure they never showed up. The pattern was not subtle, it was not hidden. It was operating in plain sight, inside a courthouse that was open to the public, filed in records that anyone could access, processed by a judge whose calendar was a matter of public record. It was not a conspiracy in the dramatic sense. There were no secret meetings, no coded messages, no men in dark rooms making deals. It was a machine, a bureaucratic machine that converted black homeownership into corporate profit through the systematic manipulation of court procedures. And the machine had a name: efficiency. Judge Gault signed the orders because signing orders was what judges did, and questioning whether an order should be signed required effort, and effort was the opposite of the path of least resistance that had defined Gault's career for 2 decades. Paige Lathrop filed the cases because filing cases was how her firm made money, and questioning whether the cases were legitimate was not part of the profit model. Niles Ogden managed the calendar because managing the calendar was his job, and whether the calendar was designed to prevent defendants from appearing was not a question the job description required him to ask. Trent Kimball enforced the writs because enforcing writs was what enforcement officers did, and whether the writs were legally valid was, as he'd told Sharice twice now, something to take up with the court. Nobody was the villain. Everybody was the machine. And the machine was eating Wisteria Ridge house by house. June 27th, the day before the hearing. Sharice was at the library, printing the final version of her motion and its 47 pages of exhibits, when her phone rang. The number was local but unfamiliar. "Ms. Redmond? This is Soleil Damas. I'm a reporter with the Dispatch. I'm working on a story about eviction rates in the 4th District, and your name came up in some court filings I've been reviewing. I was hoping—" "Who gave you my name?" "It's public record, Ms. Redmond. Your motion to vacate is on the court docket. I read it." Sharice's grip on the phone shifted. A reporter. Reporters were useful and dangerous in approximately equal measure. Useful because they had platforms. Dangerous because they had deadlines, and deadlines made people careless. "What specifically are you investigating?" Sharice asked. "The concentration of evictions in the 4th District. I've been tracking the numbers for about 6 months. Cornerstone Meridian, Graymark, and Lathrop Judge Gault, the pattern is pretty clear to anyone who pulls the filings. How far have you gotten? I have the numbers. What I don't have are the people. I need homeowners willing to talk on the record. And you want me to be one of them. I want to hear your story, if you're willing. Sharice thought about this. She thought about it the way she thought about everything, strategically, sequentially, weighing costs and benefits with the cold precision that most people found either admirable or unsettling. Not yet, she said. I have a hearing tomorrow. If I go public before the hearing, it gives the other side ammunition. They can argue I'm using the court to generate publicity rather than seeking legitimate relief. That's a very lawyerly way of putting it. It's a practical way of putting it. Ask me again after the 28th. She hung up, made a note. Soleil Damas, dispatch, investigating same pattern. Independent corroboration. Do not engage until after hearing. June 28th, 9 a.m., courtroom C. The gallery was fuller than usual. Calvin Trask sat in the second row, legal pad on his knee, looking like a man who hadn't slept because a man who hadn't slept was exactly what he was. Marvina Pickett sat beside him, representing her mother's interests through a power of attorney that Calvin had helped her file 3 days earlier. Langston Bryce was there, in the same too-big dress shirt. Dinah Falk had taken a personal day from the hospital to attend. Sharice sat at the respondent's table alone. No lawyer beside her. Her navy notebook on the table, 3 folders stacked neatly. The spreadsheet printed in a font large enough for a 62-year-old judge to read without squinting. Paige Lathrop arrived at 8:55. She walked in the way people walk into rooms they consider their own, without hesitation, without looking around, without acknowledging the other occupants as anything more than furniture that happened to be breathing. She set her leather portfolio on the plaintiff's table, opened it, and began reviewing documents with the relaxed efficiency of someone who expected this to take 15 minutes. She glanced across the aisle at Sharice, looked at the navy notebook, the folders, the spreadsheet, looked at Sharice's flat shoes and cotton blouse and reading glasses on their beaded chain. And she smiled. It was the same smile the associate had given in the hallway 2 weeks ago, the smile of a predator assessing prey and finding it insufficiently threatening. But Lathrop's version was more refined, more controlled. The smile of a woman who had won 94% of her eviction cases and saw no reason why this one would be different. Gault entered. Everyone rose. He sat, adjusted his microphone, opened his folder. Case 24 CV-0817, Cornerstone Meridian LLC versus Redmond. This is a hearing on the respondent's emergency motion to vacate the default judgment entered May 29th. He looked at Lathrop. Counsel for the plaintiff? Paige Lathrop for Cornerstone Meridian, Your Honor. He looked at Sharice. The respondent is appearing pro se? Yes, Your Honor. Gault's expression shifted. Not quite a smile, not quite a sigh. The expression of a man who considered pro se litigants to be a form of weather, unavoidable, inconvenient, and best processed as quickly as possible. Ms. Redmond, you've filed a motion to vacate on the grounds of defective service and procedural irregularities. You have 10 minutes to present your argument. Your Honor, I believe the complexity of the evidence warrants 10 minutes, Ms. Redmond. This is an emergency motion, not a trial. Lathrop leaned back in her chair. She looked at Sharice with an expression of patient amusement, the look of a chess player watching an opponent set up the board wrong. Then Lathrop did something that would define the rest of this story. She turned slightly toward the gallery, toward Calvin Trask, toward Marvina Pickett, toward the 5 other homeowners who had come to watch, and said, not quite under her breath, but not quite out loud either, in that precise volume calibrated to be heard by everyone who mattered and denied to everyone who challenged it. Win this case, and I'll quit. A sound came from the bench. Short, involuntary, quickly suppressed. Judge Harlan Gault was laughing. Not a full laugh. A breath through the nose, a compression of the lips. The micro-expression of a man who found the idea of a woman in flat shoes and a beaded chain beating Paige Lathrop in his courtroom to be genuinely, sincerely funny. He caught himself, composed his face, but the gallery had heard it. Calvin Trask had heard it. Marvina Pickett had heard it. Sharice had heard it. And Sharice, who had spent 15 years in courtrooms where she was the one sitting behind the bench, where she was the one whose laugh could end a career, where she was the one whose signature on an order could put a corrupt official in prison, opened her notebook, looked at the judge who was laughing at her, and began. Your Honor, I'd like to enter into the record the following documents. She placed the first folder on the table. Exhibit A, United States Postal Service tracking data for my residential address from May 1st through June 14th. This data shows that no certified mail from this court or from Graymark and Lathrop was delivered to or attempted at my address during that period. Service was not completed. Second folder. Exhibit B. The eviction order in this case, stamped with a filing date of May 29th and a signed date of May 29th. Same day. This court's own rules of civil procedure require a minimum 7-day notice period between filing and default judgment. No notice was provided. No hearing was held. Third folder. The spreadsheet. 47 pages. Exhibit C. A compilation of 214 eviction cases filed in this district over the past 24 months, all filed by Graymark and Lathrop on behalf of Cornerstone Meridian LLC, all assigned to this courtroom, all processed by default. 157 of the 214 defendants are black homeowners. The average time from filing to signed order is... Ms. Redmond. Gault's voice had changed. The boredom was gone. Something else had replaced it. Not alarm, not yet, but the first faint tremor of a man who realizes the weather has shifted and the storm is not the kind he prepared for. This hearing concerns your case, not 200 other cases. Your Honor, the pattern is directly relevant to the question of whether the defective service in my case was an isolated error or part of a systematic... I said this hearing concerns your case. His voice was harder now. The gavel was in his hand, though he hadn't struck it. Confine your argument to the facts of Case 0817, or I will end this hearing. Sharice looked at him, looked at the gavel, looked at Paige Lathrop, who had stopped smiling. Then I will confine myself to the facts, Sharice said. Fact, I was never served. Fact, the order was signed the same day it was filed. Fact, enforcement was attempted 19 days before the statutory waiting period expired. Fact, during enforcement, the officer made unauthorized physical contact with me twice, resulting in documented injuries. She held up her wrist. The bruise from June 21st had faded to yellow-green, but was still visible. Fact, my personal property was removed in garbage bags rather than the sealed containers required by State Code 735.020. Fact, no inventory was created. These are the facts of Case 0817, Your Honor, all of them documented, all of them supported by the exhibits before you. Gault stared at her. Then he looked at Lathrop. Counsel? Response? Lathrop stood, smoothed her jacket, composed herself with the practiced ease of a woman who had heard arguments like this before and had a script for neutralizing them. Your Honor, the respondent's claims of defective service are unsupported by anything other than her own self-serving assertions. Our records show certified mail delivered on June 3rd. If the respondent did not check her mail, that is not a defect in service. It is a defect in the respondent's attention to her own affairs. I have USPS tracking data, Sharice began, which the respondent could have obtained and manipulated at any time, Lathrop said. Your Honor, this is a straightforward default case. The respondent missed her deadline. The order was entered properly. The enforcement was conducted in accordance with the writ. The respondent's injuries, if they exist, are a matter for a separate complaint, not grounds to vacate a valid court order. Gault nodded. He was looking at the spreadsheet, not reading it, but looking at it, the way a man looks at a document he doesn't want to exist. I'm going to take this under advisement, he said. The court will issue a ruling within 7 business days. In the interim, the eviction order remains in effect. Enforcement is not stayed. Sharice's voice cut through the courtroom. Your Honor, with respect, if the order remains in effect during review, my home will be sold before you issue a ruling. Cornerstone Meridian's purchase contracts close within 10 business days of eviction. 7 days of advisement, plus 10 days of closing means my house will belong to the plaintiff before you've decided whether the eviction was legal. The courtroom was silent. Gault's face did something complicated. A tightening around the eyes, a flattening of the mouth, the expression of a man who has just been told, in public, that his process is designed to produce an outcome before his review can prevent it. The timeline of private transactions is not this court's concern, he said. Ruling in 7 days. This hearing is adjourned. He struck the gavel, rose, left through the side door. Paige Lathrop gathered her portfolio. She looked at Sharice, a long, assessing look, the first one that contained something other than amusement. Then she leaned across the aisle, close enough that only Sharice could hear, and said, Nice try, but you're out of your depth, Ms. Redmond. This courthouse isn't a library. You can't check out a win and return it when you're done. She walked out. Subscribe and turn on notifications, because what Paige Lathrop doesn't know about the woman she just dismissed is about to change everything. Part 2 is coming. Sharice sat at the respondent's table for a long time after the courtroom emptied. Calvin Trask came and sat beside her. I've never seen a pro-se litigant do that, he said. Do what? Make Gault uncomfortable. He took it under advisement. He never takes eviction motions under advisement. He rules from the bench, always. He took it under advisement because he doesn't know what to do with the spreadsheet, Sharice said. He can dismiss my case on procedure. He can't dismiss 214 cases, not without someone asking why. Calvin looked at her. He'd been looking at her with increasing frequency over the past 3 weeks, the way a person looks at a puzzle that keeps revealing new edges. Ms. Redmond, I've been practicing in this court for 4 years. I've seen every kind of pro-se litigant. The angry ones, the confused ones, the ones who bring binders full of internet printouts and think they've found a secret constitutional amendment. You are not any of those people. No. The way you cite statutes, the way you organize exhibits, the way you address the judge, you didn't defer and you didn't grandstand. You spoke to him like an equal, like someone who sat where he sits. Sharice closed her notebook, placed her pen in the spine, squared the edges of her folders. Calvin, I appreciate your curiosity, but right now, my house is padlocked. My belongings are in garbage bags in a warehouse I can't locate, and a judge who laughed at me is deciding whether I get to keep the property I own. That's what matters today, not who I used to be. Calvin nodded, accepted it. But as they walked out of the courtroom together, he held the door for her, not the casual door holding of a younger man for an older woman, but the deliberate, measured gesture of someone who has just realized that the person beside him carries a weight he doesn't fully understand, but has decided to respect. Outside the courthouse, in the June heat, Sharice's phone buzzed. A text from an unfamiliar number. Ms. Redmond, my name is Eunice Rowe. I'm a retired judge, 12th District, not 14th. I heard about your hearing today from a colleague. I'd like to talk, not as a judge, as a neighbor. I live on Magnolia, 3 blocks from Wisteria Ridge. Sharice read the message twice. A retired judge, 3 blocks away, reaching out after one hearing. Word traveled fast in courthouses, faster than filings, faster than orders, faster, sometimes, than justice. She typed back, tomorrow. 10 a.m., the coffee shop on 4th Street. Then she put her phone away and walked toward Marvina's apartment, carrying her 2 boxes and her 14 notebooks and the bruise on her wrist and the knowledge that Judge Harlan Gault had laughed at her this morning, and that somewhere in the next 7 days, in a ruling he had not yet written, he would have to decide whether to keep laughing or start worrying. She already knew which one she'd bet on. But Sharice Redmond also knew, in the quiet, certain way of a woman who had spent a career watching the powerful protect themselves, that the real danger wasn't a judge who laughed. It was a judge who stopped laughing and started making phone calls. The phone in Gault's chambers was already ringing, and the person on the other end was not someone Sharice had mapped yet. Not yet. That night, sitting in Marvina's kitchen at 11 p.m., Sharice opened her laptop and checked the court's electronic filing system. Her motion was listed. Status, under advisement. But something else had changed. The filing date on her original motion, the one she had submitted on June 14th, time-stamped by Niles Ogden at 9:33 a.m., now showed a different date in the system. June 15th. 1 day later. 1 day that would push her 14-day window back by 24 hours. 1 day that would technically make her refiling deadline fall on June 29th instead of June 28th. 1 day that would mean today's hearing had occurred 1 day, before the system said she was eligible to be heard. 1 day that gave Gault grounds to throw out her motion on a technicality. She checked the system audit log, the record of changes made to filings, accessible through a public transparency portal that most people didn't know existed. The log showed one modification to the filing date, made at 11:47 p.m. on June 14th, from a clerk's administrative account. User ID, Nogden. Niles Ogden had changed her filing date. 9 hours after she submitted it, 11:47 at night, long after the clerk's office closed. Sharice took a screenshot, then another. Then she opened her notebook and wrote, in letters that pressed hard enough to leave an impression on the page beneath, June 28th, 11:03 p.m. Filing date. Altered in CCMS. Original, June 14th. Changed to June 15th. Modification timestamp, June 14th, 11:47 p.m. User, Nogden. This alteration creates grounds for procedural dismissal of my motion. She stared at the words. Then she picked up her phone and texted Calvin Trask. Check your filing dates in the system, all of them, tonight, compared to your paper receipts. His reply came 4 minutes later. Why? Because someone is changing them. The reply after that came in 11 minutes. 11 minutes of what Sharice imagined was Calvin Trask sitting at his own kitchen table, pulling up case after case, comparing timestamps, feeling the slow, nauseating realization of a man who has just discovered that the ground he's been standing on has been moving beneath him. 3 of his filing dates had been changed. All 3 pushed back by 1 day. All 3 created procedural grounds for dismissal. All 3 were modified from the same administrative account. Nogden. Calvin's final text of the night was 2 words. What now? Sharice typed her response, deleted it, typed it again, deleted it again. She wanted to say, now we burn it down. She wanted to say, now we call the FBI. She wanted to say, now I tell you who I really am, and we end this in a week. But she had been in this work long enough to know that burning things down was satisfying and ineffective, that the FBI moved on federal timelines that made glaciers look hasty, and that revealing her identity too soon would give the machine exactly the ammunition it needed to reframe the story. Not a systematic theft of black homes, but a vendetta by a disgruntled former government official with an axe to grind. She typed, now we document, and then we wait for the right moment. She set the phone down, closed the laptop, sat in the dark kitchen, listening to the hum of Marvina's refrigerator and the distant sound of a train and the particular silence of a woman who has spent 14 months building a case that nobody asked her to build, in a courthouse that didn't know she was dangerous, against a machine that had never encountered anyone patient enough to map its entire architecture before pulling the first lever. The right moment was coming. But first, it was going to get worse. June 30th, 2 days after the hearing. No ruling from Gault. Sharice arrived at the 4th Street coffee shop at 9:55 a.m., 5 minutes before the agreed time with Eunice Rowe. She ordered black coffee, sat facing the door, and opened her notebook to a fresh page. Eunice Rowe entered at exactly 10, 71 years old, gray locks gathered in a low knot, wearing linen trousers and a blouse that had the particular quality of expensive fabric maintained for decades rather than replaced. She walked with a cane, not leaning on it, using it, the way a person uses a tool they've accepted without resentment. She scanned the room, found Sharice, and sat across from her without pleasantries. "You rattled Harlan Gault," Eunice said. "I've known him for 22 years. He doesn't take things under advisement. He doesn't think. He signs." "That's the problem." "That's one problem. You have several." Eunice set her cane against the table. "I heard about the spreadsheet. 214 cases. That's not something a homeowner puts together. That's something an investigator puts together. Or a prosecutor." Sharice sipped her coffee, said nothing. "I'm not asking you to confirm anything," Eunice said. "I'm telling you what other people are going to conclude when they see that document, and some of those people will use that conclusion against you. They can conclude whatever they like. The data is public record. The data is public. The analysis isn't. The way you organized it, by demographics, by judicial assignment, by filing to order timelines, that's pattern analysis. That's the kind of work that state attorneys general do when they investigate institutional discrimination." Sharice looked at her. Eunice looked back. Two women in a coffee shop, one reading the other with the precision of someone who had spent 3 decades on the bench and could parse a witness the way a linguist parses a sentence. "You know Gault," Sharice said. "How does he respond to pressure?" "He caves, always has. He got the bench because he was inoffensive, not because he was capable. He signs what's put in front of him because the people who put things in front of him are the people who helped him get appointed. Paige Lathrop's firm contributed to every judicial retention campaign in this district for the past 15 years. Then who does he call when he's scared?" Eunice's mouth thinned. "Judith Calder. The councilwoman. The councilwoman who sits on the Judicial Nominating Commission, the one who recommended Gault for the bench in the first place, the one whose Community Renewal Initiative provides the political cover for every property acquisition Cornerstone Meridian makes. You know about Cornerstone Meridian. I know that 3 houses on Magnolia Street, my street, have been acquired by an LLC that didn't exist 2 years ago, at prices that don't reflect market value, after evictions that followed a pattern I recognized because I spent 30 years watching cases, and I know what an assembly line looks like, even when it's wearing a judge's robe." Sharice closed her notebook. "Why didn't you do anything?" Eunice's face changed. Not anger, something older than anger. Resignation that had been weathered into something more useful but no less painful. "Because I'm retired. Because I have no jurisdiction. Because I filed a complaint with the Judicial Conduct Commission 4 months ago and received a form letter saying it was under preliminary review and have heard nothing since. Because the system I spent my career inside is the same system that's eating your neighborhood, and I don't know how to fight it from the outside." She leaned forward. "But you do. I don't know how, and I don't need to know how. What I need to know is whether you're prepared for what happens when they figure out you're not just a homeowner. They won't figure it out. Paige Lathrop will. She's not stupid. She's corrupt and she's predatory, but she's not stupid. She'll run your name. She'll pull every public record she can find. And when she discovers whatever it is you're not telling me, she won't use it to fix her behavior. She'll use it to destroy your credibility." Sharice considered this. Eunice was right. Lathrop was already recalibrating. Sharice had seen it in the courtroom, in the shift from amusement to assessment, in the moment when Lathrop stopped smiling and started looking. "How long do I have?" "Before she connects the dots? A week. Maybe 2. Depends on how deep she digs and how well you buried it." "I didn't bury anything. I just stopped using it." Eunice studied her for a long moment. Then she reached into her bag and pulled out a single sheet of paper, a printout from the Judicial Conduct Commission's complaint portal. "My complaint. Case number JCC 24-112. Filed February 19th. Status, under review. No investigator assigned. No timeline for resolution." She placed it on the table between them. If you add your evidence to this complaint, the spreadsheet, the filing date alterations, the enforcement violations, it changes the weight class. A retired judge complaining about a colleague is gossip. A retired judge and a documented pattern with 214 data points is a case. Sharice picked up the paper, read it, recognized in its careful, thorough language the work of a woman who had spent decades writing opinions and knew exactly how to construct an argument that could survive scrutiny. "I'll add my documentation," Sharice said, "but not yet." "Why not yet?" "Because I need to see how Gault rules. If he dismisses my motion on the altered filing date, if he uses Ogden's change as grounds, then I don't just have a pattern of eviction fraud. I have a judge relying on fabricated court records to deny relief. That's not an administrative complaint. That's obstruction." Eunice's eyes narrowed. Respect, maybe, or recognition. "You think like a prosecutor." Sharice finished her coffee. "I think like a homeowner who wants her house back." July 1st. Sharice was walking back to Marvina's apartment from the library when a car pulled up beside her on Oleander Street. White sedan, the same white sedan that had been parked behind Kimball's truck during the second eviction enforcement. The window rolled down. A woman leaned out, 40s, auburn hair pulled back tight, a silk scarf despite the 90-degree heat. She smiled the way people smile when they want you to know they're smiling. "Ms. Redmond?" Sharice stopped, kept 2 feet between herself and the car. "I'm sorry. Do I know you?" "Judith Calder. I'm your district councilwoman. I was hoping we could talk. Do you have a few minutes?" "We can talk right here." Calder's smile didn't waver. "I'd prefer somewhere private. There's a lot of misinformation floating around about the development projects in the 4th District, and I'd hate for you to get caught up in something based on incomplete—" "I'm comfortable right here, councilwoman." The smile finally dimmed. Calder opened the car door and stepped out. She was taller than Sharice expected, 5'9" in heels, and she carried herself with the particular confidence of someone who was accustomed to controlling the temperature of every room she entered. "Fine. I understand you've been making inquiries about Cornerstone Meridian, pulling records, filing motions. That's public information." "It is, and I'm here as a public servant to let you know that the Community Renewal Initiative is a transparent, fully documented, legally authorized—" "Councilwoman, are you here to discuss my eviction case?" Calder paused. "I'm here to offer context." "Context for what? For why 73% of the homeowners evicted under your renewal initiative are black? For why every one of those evictions was signed by the same judge on the same day the filing was submitted? For why—" Calder stepped closer, close enough that Sharice could smell her perfume. Expensive, floral, applied with precision. Close enough that Sharice had to tilt her head back slightly to maintain eye contact. "Ms. Redmond." Calder's voice dropped. Not a whisper. The register below a whisper, the one that's meant to convey intimacy and threat in equal portions. "I'm offering you a conversation, a chance to understand the full picture. Because right now, the picture you have is incomplete, and incomplete pictures lead to incomplete conclusions, and incomplete conclusions lead to lawsuits that go nowhere and leave the person who filed them in a worse position than when they started." Is that a warning? It's advice, from someone who knows how this district works. "I know how this district works, councilwoman. I have 214 examples." Calder held the look for 3 more seconds, then she stepped back. The smile returned, but it had changed composition. Less warmth, more enamel. "I hope you reconsider," she said. "My door is always open." She got back in the car. The window rolled up. The sedan pulled away. Sharice stood on Oleander Street and wrote, "July 1st, 3:17 p.m., Councilwoman Judith Calder. Unsolicited contact. Approached on street. Attempted to discourage investigation. Referenced incomplete pictures and implied legal consequences. No witnesses present." She underlined the last line twice. Then she looked up and noticed something she hadn't noticed before. A car parked across the street. Gray, nondescript, engine idling. Through the windshield she could make out a figure in the driver's seat, phone raised, pointed in her direction. The car pulled away before she could read the plate. She wrote, 3:19 p.m. Gray vehicle. Make/model unknown. Parked opposite 300 block Oleander during Calder encounter. Occupant appeared to be photographing or recording. Vehicle departed when observed. She put the notebook in her bag and walked the remaining 3 blocks to Marvina's apartment without looking back. But she listened. She listened the way a woman listens when she has spent a career in rooms where the people across the table had everything to lose and nothing left to lose it with. She listened for footsteps that matched her pace, for engines that idled too long, for the particular quality of attention that separates observation from surveillance. The street was quiet, for now. July 3rd, 5 days since the hearing. No ruling from Gault. Calvin Trask called at 7 a.m. He's not going to rule, Calvin said. What? Gault. He's not going to rule within the 7-day window. I called the clerk's office. Ogden told me, and I quote, the judge's calendar has been adjusted to accommodate unforeseen administrative obligations. Indefinite delay. No new date. Sharice set down her coffee. He's running out the clock. That's what it looks like. If he doesn't rule, the eviction order stays active. Cornerstone Meridian can close on your property. By the time a ruling comes, if it comes, there's nothing to vacate because the house won't be yours anymore. Sharice looked at her notebook. 14 months of entries. 214 cases. A pattern so clear that a first-year law student could map it. And a judge who had decided that the most efficient response to being confronted with evidence of systemic fraud was to simply stop making decisions and let the machine run on autopilot. Calvin, she said, I need you to do something. Name it. File a writ of mandamus with the appellate court. Compel Gault to rule. Silence. A long one. Ms. Redmond, a writ of mandamus against a sitting judge. That's not something a legal aid attorney does. That's nuclear. The Bar Association will notice. The Judicial Nominating Commission will notice. Judith Calder will definitely notice. Good. Ms. Redmond. Calvin. My house is being sold. Orally Pickett's house has already been sold. Langston Bryce's house is scheduled to close next week. Dinah Falk can't find her belongings. 7 other homeowners are in the same position. And the judge, who is supposed to decide whether any of this is legal, has decided not to decide. If you don't file the mandamus, I'll do it myself. But it will carry more weight coming from an attorney of record. More silence. Then, I'll file it tomorrow. Today. Ms. Redmond, it's July 3rd. The courthouse closes at noon. Then you have 5 hours. He filed it at 11:42 a.m., 18 minutes before the deadline. The writ named Judge Harlan Gault and requested the Ninth Circuit Appellate Court compel him to issue a ruling on the pending motion to vacate within 72 hours. Attached to the writ, Sharice's spreadsheet, the USPS tracking data, the screenshots of the altered filing date, and a sworn affidavit from Sharice Redmond describing the physical conduct of enforcement officers during 2 eviction attempts. The appellate court acknowledged receipt at 11:58 a.m., 2 minutes before the courthouse doors closed for the holiday. Sharice sat in Marvina's kitchen and stared at the confirmation email on her laptop screen. The machine had never been challenged from above. Not once, in 24 months of operation, had anyone climbed over the walls of the 14th District and asked a higher court to look down at what was happening inside. The machine relied on isolation, on the assumption that each case was individual, each eviction was routine, each default judgment was unremarkable. It relied on the fact that the people being evicted didn't know each other, didn't talk to each other, didn't compare their experiences. It relied on silence. Sharice Redmond was not silent, and the appellate court was now reading the same spreadsheet that had made Judge Harlan Gault stop laughing and start stalling. The question was no longer whether he would rule. The question was who he would call first, Paige Lathrop, Niles Ogden, or Judith Calder, and whether any of them would pick up. July 5th. The holiday ended. The courthouse reopened, and the appellate court moved faster than anyone in the 14th District expected. At 8:22 a.m., Calvin Trask received an email from the Ninth Circuit Appellate Court, case reference AC-24-0731. He read it standing in his kitchen with a bowl of cereal going soggy on the counter. Then he read it again. Then he called Sharice. They granted the mandamus. Sharice was sitting at Marvina's kitchen table, where she had been sitting since 5:15 a.m., where she sat every morning now, in a chair that wasn't hers, in a home that wasn't hers, living the displaced life that 157 other homeowners in the 4th District were also living. How long? 48 hours. Gault has 48 hours to rule on your motion to vacate, or the appellate court will transfer the case to a different judge. She set down her pen. Transfer. The order uses the phrase reassignment to avoid the appearance of procedural delay. It's the judicial equivalent of being told to do your job or lose it. What about the filing date? The appellate court noted the discrepancy. They didn't rule on it. That's still a matter for the trial court, but they flagged it. Used the phrase administrative irregularity warranting examination. That's appellate language for someone tampered with the record, and we noticed. Sharice looked at her notebook. The entry from June 28th, the one documenting Ogden's midnight alteration, stared back at her in her own handwriting. Modification timestamp, June 14th, 11:47 p.m. User, Nogden. Calvin, when the appellate order hits Gault's desk, what's his first move? Panic. Gault doesn't handle pressure. He'll call his contacts, try to figure out who pushed this up the chain. Then he'll realize there's nothing to push back against. A mandamus is a mandate, not a suggestion. He has to rule. And Lathrop? She'll file an opposition brief within 12 hours. She's fast when she's threatened. Let her. The evidence is already in the record. Every exhibit I submitted at the June 28th hearing is part of the court file now. She can't unsee the spreadsheet. Silence on the line. Then Calvin said something she didn't expect. Ms. Redmond? A pause. He always paused before her name now. Not hesitation, but emphasis. The particular weight a person puts on a title when they've stopped viewing it as a formality and started viewing it as an acknowledgement. I filed the mandamus because you asked me to. I attached your evidence because I believed it. But I need you to understand. I'm a legal aid attorney with 87 cases and a salary that doesn't cover my student loans. If Gault retaliates, if the Bar Association opens a review, if this goes sideways, it won't go sideways for you. How can you know that? Because everything I've given you is documented, sourced, and defensible. Because the mandamus was filed on valid legal grounds. And because... She stopped. Chose her next words with the precision she'd been trained to apply to sentences that could end careers or save them. Because I've done this before, Calvin. Not here, not in this district. But the architecture is the same. Courts that move too fast for defendants and too slow for justice. Clerks who control calendars. Judges who sign without reading. I've seen it before, and I've taken it apart before. You're not going to lose your license for doing the right thing. Another long pause. Then, you said you worked in government. I did. Government doing what? She looked out the window. Marvina's apartment faced east, and the morning sun was coming through the blinds in horizontal bars that striped the table like evidence lines. Ask me again after Gault rules. Gault ruled on July 6th, 29 hours after the mandamus hit his desk. The ruling was 4 pages long. Sharice read it on the court's electronic system at 3:47 p.m., sitting in the public library on 4th Street, because Marvina's Wi-Fi had gone down and the coffee shop was closed for a plumbing emergency. Page 1, Procedural History. Standard. Page 2, the court acknowledges the respondent's claim of defective service. The court notes the USPS tracking data submitted by the respondent, but observes that such data, standing alone, does not constitute conclusive proof of non-delivery. The court further notes that certified mail service is presumed valid upon filing of the sender's receipt. Page 3. The court finds that the respondent's motion to vacate was timely filed. Sharice stopped. Read the sentence again. Timely filed. The altered filing date, June 15th instead of June 14th, was not mentioned, not addressed, not acknowledged. Gault had simply ruled as though the alteration never happened, using the correct date without explaining the discrepancy, which meant one of two things. Either Ogden had quietly changed it back, or Gault had decided that acknowledging the alteration would raise questions he couldn't afford to answer. Page 4. However, the court finds insufficient grounds to vacate the default judgment at this time. The respondent's broader claims regarding patterns of conduct in other cases are outside the scope of this proceeding. The eviction order remains in effect. The respondent's motion is denied. Denied. After all of it, the evidence, the mandamus, the appellate court's intervention, Gault had found a way to thread the needle. He acknowledged enough to avoid reversal on appeal. He denied enough to keep the machine running. He used the procedural tools he'd been given by 30 years of practice to produce a result that looked legitimate on paper and tasted like corruption in the mouth. Sharice closed her laptop, sat in the library for 11 minutes without moving. A woman at the next table was helping her daughter with homework. A man in a baseball cap was reading a newspaper. The air conditioning hummed. Then she opened the laptop again and checked one more thing. County Recorder's Office. Property transfer filings. 412 Wisteria Ridge. Transfer of title. 412 Wisteria Ridge. Filed July 6, 3:22 p.m. Seller. County Sheriff. Foreclosure sale. Buyer. Cornerstone Meridian LLC. Purchase price $58,000. 25 minutes after Gault's ruling. 25 minutes. The transfer had been prepared in advance, waiting for the denial like a car with its engine running. Her house was gone. She looked at the number. $58,000. She had paid $142,000. The assessed value was $187,000. Someone had just made $129,000 by stealing her home through a courthouse. She called Calvin. "I saw it," he said before she could speak. His voice was tight, the voice of a man who was learning in real time that the system he'd spent 4 years serving was not the system he'd believed it was. The transfer was filed 25 minutes after the ruling. They had the paperwork ready. Calvin, it's time. Time for what? Time to stop playing defense. If you're watching this far, this story is about to turn in a direction nobody saw coming. Subscribe and hit the bell. You won't want to miss what happens next. July 7th. Sharice sat across from Soleil Damas at a diner 3 miles outside the 4th District, far enough from the courthouse that they wouldn't be seen, close enough that Soleil could make it back for her 2 p.m. deadline. Soleil was 34, dark-skinned, natural hair cropped close, a press badge clipped to the strap of a messenger bag that looked like it had survived 2 wars and a flood. She had a recorder on the table and a notebook open, an actual paper notebook, not a phone app. Sharice noticed this and filed it away. People who wrote by hand tended to think before they recorded. That was a quality she valued. "You said you weren't ready to talk before the hearing," Soleil said. "The hearing happened. Gault denied your motion. Your house was sold 25 minutes later. Are you ready now?" "I'm ready to give you documents, not an interview." Soleil's pen paused. Documents without context don't make a story. These documents are the story. I have the spreadsheet, 214 evictions, demographic breakdown, judicial assignment patterns, filing to order timelines. I have USPS tracking data proving non-delivery of service in my case. I have screenshots showing my filing date was altered in the court's electronic system by Senior Clerk Niles Ogden at 11:47 p.m. on the day I submitted it. I have county recorder filings showing Cornerstone Meridian LLC purchased every evicted property within 10 business days at 30 to 40% of market value. And I have Secretary of State records showing that Cornerstone Meridian's registered agent operates from the same address listed on Councilwoman Judith Calder's campaign finance reports. Soleil stopped writing, looked at Sharice, then looked at her again, the way a person looks at a photograph they've been studying and suddenly realizes contains a figure they missed. That's, Ms. Redmond, that's not a motion to vacate an eviction. That's a federal investigation. Yes. How long have you been building this? 14 months. 14, you started before your own eviction? I started when I noticed the pattern. My eviction confirmed it. Soleil set down her pen, folded her hands on the table. Reporter mode shifting to something else, the mode of a person who realizes the story she came for is not the story she's getting. I need to ask you something, and I need you to be honest, because if I publish this and it turns out the source has a hidden agenda or undisclosed connections, it kills the story and it kills my credibility. Ask. Who are you? And I don't mean your name. I mean, who are you that you know how to do this? Sharice looked at the recorder on the table, red light blinking. She reached over and pressed stop. Off the record. Soleil hesitated, then nodded. I spent 15 years as an assistant attorney general in another state. My division investigated institutional fraud, housing discrimination, predatory lending, public corruption. I built cases like this for a living. Cases with spreadsheets and audit logs and chain of custody documentation. Cases where the people doing the harm were protected by the same institutions that were supposed to prevent it. Soleil exhaled, slowly, the sound of a puzzle completing itself. Why did you stop? Burnout. The system grinds you down. You win a case, the policy changes for 6 months, then it reverts. You expose a scheme, the people running it retire with pensions and start consulting. After 15 years, I was tired of winning battles and losing wars. So I moved here, bought a house, planted a garden, stopped fighting. And then they came for your house. And then they came for my house, and for Auralie's house, and for Langston's house, and for Dinah's house, and for 210 other houses. And I realized that the thing I was tired of fighting was the thing that followed me here. Silence. The diner noise. Clinking plates, a cook calling orders, the low rumble of a truck passing outside, filled the space between them. Can I use this? Soleil asked. Not yet. Not the background. Not who I am. Not until I tell you it's time. Then what can I use? The documents, the data, the public records. Everything I've given you is independently verifiable. You don't need me as a source. You need me as a map. Follow the documents. They'll lead you to the same place I am. Soleil picked up her pen again. And where is that? Judith Calder's office. July 11th, 4 days after the diner meeting. The story broke. Soleil Damas published a 3,200-word investigative piece in the Dispatch under the headline, 4th District Evictions, a Pattern of Displacement. The article didn't name Sharice. It didn't need to. It cited the same public records Sharice had compiled, court dockets, property transfers, demographic data, Secretary of State filings, and laid out the pattern in language that was precise enough for lawyers and clear enough for everyone else. 214 evictions, 1 firm, 1 judge, 1 buyer, 1 councilwoman's development initiative, and a demographic profile that looked less like coincidence and more like targeting. The article went live at 6 a.m. By noon, it had been picked up by 3 regional outlets and a national wire service. By 3 p.m., the Judicial Conduct Commission, the same body that had been sitting on Eunice Rowe's complaint for 5 months, issued a statement. The Commission has received inquiries regarding judicial conduct in the 14th District and is evaluating whether a formal review is warranted. By 5 p.m., Councilwoman Judith Calder held a press conference on the steps of City Hall. She wore a navy suit and a flag pin, and the composed expression of a person who had rehearsed her talking points in a mirror. The Community Renewal Initiative is a transparent, fully audited program that has generated over $40 million in development investment for underserved neighborhoods in the 4th District. Any suggestion that this program targets specific communities is not only inaccurate, but harmful to the very residents it was designed to help. She took 4 questions. She answered none of them. That evening, Sharice received a text from an unknown number. Not Calder this time. Not anyone she recognized. Nice article. Enjoy your 15 minutes. By the time this is over, you won't have a house, a reputation, or a case. Some people should learn to stay quiet. She screenshotted it, noted the time, 9:47 p.m., added it to her file. Then she went to bed. She did not sleep well. At 2:14 a.m., she was woken by a sound outside Marvina's apartment. Not loud. A metallic scraping, like a key being tested in a lock that doesn't fit. She lay still, listening. The sound stopped. Sound, footsteps, quick, receding. A car door. An engine. She got up and checked the front door. Locked. She looked through the peephole. Empty hallway. She checked the parking lot from the window. A gray sedan, the same make and color as the one that had been watching her on Oleander Street, was pulling out of the lot with its headlights off. She wrote, July 12th, 2:14 a.m. Sound at front door. Gray sedan departing without headlights. Possible surveillance or intimidation. Third sighting of similar vehicle. In the morning, she found something on the doormat that hadn't been there when she locked up. A manila envelope. No name, no address, no postage. Inside, a single sheet of paper. A printout of her old state bar profile from the state where she'd served as assistant AG, her photograph, her license number, her division, consumer protection and public integrity. Beneath the printout, handwritten in red ink, "We know who you are." Sharice held the paper by its edges, examined the handwriting, blocky capitals, ballpoint pen, right-handed pressure pattern. She placed it in a plastic sleeve from her document kit and added it to the evidence folder. They knew. Whoever they were, Lathrop, Calder, someone working for either or both, they had connected the dots. Eunice Rowe had predicted this. 2 weeks, she'd said. It had taken 9 days. The question now was not whether they would use it against her. The question was, how? July 14th. Exactly 1 month since Trent Kimball had first appeared at her door. The Judicial Conduct Commission announced a formal review of Judge Gault's handling of eviction cases in the 14th District, case number JCC-24-0287. Investigating judge, the Honorable Warren Sloan, appointed from the 3rd District to avoid conflicts of interest. The same day, Sharice received a call from an attorney she'd never spoken to. Ms. Redmond, this is Dana Cavell. I'm with the State Attorney General's Office, Civil Rights Division. We've been reviewing the dispatch article and the court filings associated with your case. We'd like to schedule a meeting. Sharice sat on Marvina's couch with the phone pressed to her ear and felt, for the first time in 14 months, the particular vertigo of a plan that was working. I'm available tomorrow. Tomorrow works. 10 a.m. at the Federal Building. Bring everything you have. She brought everything she had. 14 notebooks, 47 pages of spreadsheet data, USPS tracking confirmations, screenshots of the altered filing date, county recorder filings, Secretary of State business registrations, campaign finance disclosures, copies of the eviction orders for her case and 11 others, affidavits from Langston Bryce, Dinah Falk, and Marvina Pickett on behalf of her mother, photographs of the bruises on her wrist, and a USB drive containing every audio recording from her personal device. Every word Trent Kimball had said, every threat, every grab, every procedural violation captured in digital clarity. She packed it all in 2 boxes, the same 2 boxes she'd carried out of her house on June 21st, and drove Marvina's car to the Federal Building. Dana Cavell was in her early 40s, black, with close-cropped hair, and the expression of someone who had heard a lot of stories and was reserving judgment until she'd heard this one. Beside her sat a younger attorney, male, white, taking notes on a tablet with the speed of someone trained to capture everything and evaluate nothing until later. Sharice placed the boxes on the table. "I'll start at the beginning," she said. "Please." She began, not with the eviction, not with Kimball at her door. She began 14 months earlier, when she noticed the first for sale sign on Wisteria Ridge, a house she knew was occupied, owned by a family she knew by name, sold to an entity she'd never heard of at a price that made no sense. She walked them through the pattern, one case at a time, one document at a time. She cited dates and case numbers from memory, not because she had a perfect memory, but because she'd written every one of them in her notebooks and had reviewed them so many times that they lived in her the way a musician carries a song. 2 hours. She spoke for 2 hours. Calder interrupted 3 times, to clarify a date, to ask about a source, to request a specific document. Each time, Sharice produced it from the box without searching. Tab, folder, page number. When she finished, Calder looked at the younger attorney. He looked back. A conversation passed between them in the language of people who work together long enough to communicate in glances. Then Calder turned to Sharice. "Ms. Redmond, I need to ask you something that's going to determine how we proceed." "Go ahead." "Our office ran a background check on you when your name appeared in the court filings, standard procedure for potential witnesses in civil rights investigations." She opened a folder of her own. Sharice Redmond, born 1971, bachelor's degree, Howard University, Juris Doctor, Georgetown Law, admitted to the bar in 2001, appointed Assistant Attorney General, Consumer Protection and Public Integrity Division, 2005, served until 2020, 15 years, specialized in housing fraud, predatory lending, and institutional corruption. The room was silent. "You're not a homeowner who happens to be good at research," Calder said. "You're a career prosecutor who moved to the 4th District, identified a systematic fraud scheme, and spent 14 months building a case from the inside." Sharice looked at her hands, at the faded bruise on her wrist, at the 2 boxes of evidence she'd carried out of her own house, while a man in steel-toed boots stuffed her mother's letters into garbage bags. "I'm both," she said. "Excuse me?" "I'm both. I'm a career prosecutor and a homeowner who lost her house. Those aren't contradictions. The fact that I know how to build a case doesn't mean the case isn't mine. They took my home, Ms. Calder. They took Oralee Pickett's home. They took Langston Bryce's home. They took Dinah Falk's home while she was under anesthesia. I didn't start this investigation because I'm a prosecutor. I started it because I'm a neighbor." Calder closed the folder. "I appreciate that. And I want you to know, your background doesn't invalidate your evidence. If anything, it makes the evidence more credible, because we know it was collected by someone who understands chain of custody and admissibility." But, Calder leaned forward, "the other side will use it. The moment your professional history becomes public, Paige Lathrop will argue that you manufactured this case as a vendetta, that you moved to the 4th District specifically to target Judge Gault, that your eviction was a setup, that you bought the house, waited for the scheme to reach your street, and then used your prosecutorial training to create a narrative that would generate media attention and legal consequences. That's not what happened. I believe you, but belief isn't evidence. And the narrative Lathrop will construct is simpler, cleaner, and more emotionally satisfying than the truth. Vengeful ex-prosecutor tricks the system is a better headline than exhausted woman who retired from fighting discovers she can't stop. Sharice nodded. She had known this was coming. Had known it since the day she decided to stay on Wisteria Ridge instead of selling and moving somewhere the machine hadn't reached yet. "How do we manage it?" she asked. "You get ahead of it. You disclose your background yourself, on your terms, in a public proceeding, not in a newspaper article. That looks like grandstanding. In a filing, in testimony, in a setting where the record captures your disclosure as voluntary transparency, not forced confession. The Judicial Conduct Commission hearing. The Judicial Conduct Commission hearing. July 22nd. The hearing was scheduled for August 5th, 14 days away. In the interim, the 4th District became a place where the normal rules of gravity no longer applied. Niles Ogden submitted his retirement paperwork on July 16th, effective immediately. No exit interview, no forwarding address. The clerk's office issued a statement. Mr. Ogden has chosen to retire after 23 years of distinguished service. We wish him well in his future endeavors. Distinguished service. 23 years of controlling the calendar, managing the filings, and, if the audit log was accurate, altering court records at 11:47 at night to help a judge deny relief to a homeowner whose house was being stolen. Calvin Trask confirmed. 4 other attorneys in the 4th District had discovered altered filing dates in their cases. All 4 were eviction matters. All 4 involved Cornerstone Meridian LLC. All 4 had been assigned to Judge Gault. The pattern was not ambiguous. It was institutional. On July 18th, Paige Lathrop filed a motion with the Judicial Conduct Commission requesting that the hearing be limited in scope to the specific judicial conduct of Judge Gault, and that extraneous testimony from non-party witnesses with potential conflicts of interest be excluded. The motion didn't name Sharice. It didn't need to. Non-party witness with a potential conflict of interest was a 6-word description of a former prosecutor testifying about a judge in a district where she had a pending case. The motion was denied. Judge Warren Sloan, the investigator appointed from the 3rd District, wrote a 1-paragraph order. The scope of this review includes all evidence relevant to the conduct under examination. The Commission will determine admissibility at the hearing. On July 23rd, Trent Kimball was placed on paid administrative leave pending an internal review of enforcement procedures in the Civil Division. The press release called it a routine operational assessment. Sharice noted the language. Paid administrative leave was not discipline. It was a waiting room. The system putting a body in storage until it decided whether to protect it or sacrifice it. On July 25th, someone slashed the rear tire of Marvina's car, the car Sharice had been using, in the parking lot of the 4th Street Library. No witnesses, no cameras in that section of the lot. Sharice changed the tire herself, documented the cut, clean, diagonal, made with a box cutter or utility knife, not a nail or road debris, and added it to the file. On July 28th, Langston Bryce called Sharice. His voice was shaking. They offered me money. Who? A man came to my apartment, said he was from a property resolution firm, said they could return my house to me, full ownership, no cost, if I signed a release waiving all claims against Cornerstone Meridian, Graymark and Lathrop, and any associated parties. Did you sign? No. But he said if I didn't sign by Friday, the offer would expire permanently, and they'd pursue a deficiency judgment against me for the costs of the eviction. A deficiency judgment for the costs of stealing his house. The machine was now billing its victims for the expense of victimizing them. Don't sign anything, Langston. Forward the paperwork to Calvin, and write down everything the man said. His name, his description, the firm he claimed to represent, the exact language of the offer. He didn't give a name, didn't leave a card, just a printout with the terms and a signature line. Keep the printout. Don't touch it more than you have to. Fingerprints. She hung up, made a note, then made a call. Soleil. They're approaching the victims with settlement offers. Conditional on waiving claims? Conditional on silence. How many? At least 1, probably more. They're going door to door before the hearing. Can I report that? You can report that unnamed sources confirm settlement offers are being made to 4th District homeowners ahead of the August 5th hearing. Don't name Bryce. Don't name the firm. Let them deny it. The denial itself becomes the story when we produce the paperwork. Soleil published the report on July 30th. Graymark and Lathrop issued a statement. Our firm does not engage in pre-hearing settlement negotiations and considers any suggestion to the contrary defamatory. The dispatch ran the denial alongside a redacted copy of the settlement offer Langston Bryce had received, redacted to protect Bryce's identity, but detailed enough to make the denial look precisely as hollow as it was. August 5th, the hearing. The Judicial Conduct Commission met in Courtroom A of the 3rd District Courthouse, neutral territory, 60 miles from the 14th District, selected specifically to remove the proceeding from Gault's sphere of influence. The room was larger than Courtroom C, better lit, with modern sound equipment and a gallery that could hold 200. It held 173. Reporters occupied the first 2 rows. Soleil Damas had a reserved seat, press badge visible. Behind her, Calvin Trask, Marvina Pickett, Langston Bryce, Dinah Falk, and 11 other homeowners from the 4th District, people who had driven an hour to sit in a courtroom and watch a system that had taken their homes be asked to explain itself. Eunice Rowe sat in the 3rd row, cane between her knees, watching with the steady attention of a woman who had spent 30 years on the other side of the bench and understood exactly what was at stake. Paige Lathrop sat at a table on the right side of the room with 2 associates and a litigation partner from a firm Sharice didn't recognize, outside counsel, brought in specifically for this proceeding. Lathrop wore a dark gray suit and an expression of controlled readiness. She had come to fight. Judge Gault sat at a separate table, flanked by his own attorney, a man named Everett Nash, silver-haired, bow-tied, specializing in judicial defense. Gault looked diminished. Not the silver-haired authority who had laughed from the bench 6 weeks ago. A smaller man, grayer, with the hunted posture of someone who has realized that the walls he built to protect himself are now the walls closing in. Judge Warren Sloan presided. 67, lean, with reading glasses he wore on a chain, not unlike Sharice's beaded chain, she noticed, and the particular patience of a jurist who had been asked to evaluate a colleague and understood that the task required precision, not speed. This is a formal review hearing of the Judicial Conduct Commission, case number JCC 24-0287, concerning the conduct of Judge Harlan Gault of the 14th Judicial District. The Commission will hear testimony and review evidence pertaining to allegations of procedural irregularity, potential conflicts of interest, and patterns of judicial conduct in civil eviction proceedings. He turned to the AG's representative. The state will present its case first. Ms. Cavell. Dana Cavell stood, composed, direct, no wasted motion. The state calls Sharice Redmond. Sharice rose from the gallery, walked to the witness table, sat down, adjusted the microphone, opened her notebook. 173 people watched her. Paige Lathrop watched her with the focus of a woman who had spent the past 9 days learning everything there was to learn about Sharice Redmond and was waiting for the right moment to deploy it. Ms. Redmond, Cavell began, before you testify regarding the specific conduct under review, I'd like you to make a disclosure to the Commission. Yes. Sharice looked at Sloan, then at the gallery, then at Gault, who would not meet her eyes. Before moving to the 4th District 7 years ago, I spent 15 years as an Assistant Attorney General in the state of Maryland. My division was Consumer Protection and Public Integrity. I specialized in investigating housing fraud, predatory lending, and institutional corruption in judicial and administrative systems. The gallery murmured. Reporters wrote. Lathrop's pen stopped. She looked at Sharice with an expression that combined confirmation, calculation, and something Sharice hadn't seen before, a flicker of genuine concern. Not fear, not yet. But the first recognition that the woman in flat shoes was not the opponent Lathrop had prepared to face. Gault's attorney leaned toward his client and whispered something. Gault's face went pale. I make this disclosure voluntarily, Sharice continued, to ensure full transparency regarding my qualifications and potential biases. I am testifying today not as a prosecutor, but as a property owner who was evicted from her home through proceedings I believe were procedurally defective. My professional background informs my testimony but does not alter the facts I will present. Those facts are documented, sourced, and independently verifiable. Sloan nodded. The Commission notes the disclosure. You may proceed with your testimony, Ms. Redmond. This is the moment everything changes. Subscribe now, because the receipts Sharice is about to read into the record will leave you speechless. And then she began. Not with arguments, not with accusations, with documents, one at a time. Read into the record with timestamps, case numbers, and source attributions, the way she had read 10,000 documents into 10,000 records across 15 years of prosecutions. Exhibit 1. Eviction Order, Case 24CV-0817, filed May 29th by attorney Paige Lathrop on behalf of Cornerstone Meridian LLC, signed by Judge Gault on May 29th. Same date as filing. No hearing was held. No notice was provided to the respondent. Time between filing and judicial signature, 0 days. She placed the document on the evidence table. Exhibit 2. USPS Tracking Inquiry for Residential Address 412 Wisteria Ridge, covering May 1st through June 30th. No certified mail delivery from this court or from Graymark and Lathrop was attempted or completed during that period. The court's claim of service by certified mail on June 3rd is unsupported by postal records. Second document on the table. Exhibit 3. Court Electronic Filing System Audit Log for Case 24, CV-0817. A modification to my motion's filing date was made at 11:47 p.m. on June 14th from the administrative account of Senior Clerk Niles Ogden, user identification NOGDEN. The original filing date of June 14th was changed to June 15th. This alteration would have created grounds for procedural dismissal of my motion. She paused, looked at Sloan. Exhibit 4. A compilation of 214 eviction cases in the 14th District over 24 months, all filed by Graymark and Lathrop, all assigned to Judge Gault's courtroom, all processed by default judgment. 157 of the 214 defendants, 73%, are black homeowners. Average time from filing to signed order, 0 to 1 day. State average for comparable proceedings, 47 days. She placed the spreadsheet on the table. 47 pages, 3 months of data entry, 14 months of observation. Exhibit 5. County Recorder filings showing property transfers for all 214 evicted addresses. In each case, the property was purchased by Cornerstone Meridian LLC within 10 business days of eviction at prices ranging from 29 to 41% of assessed market value. Exhibit 6. Secretary of State Business Registration for Cornerstone Meridian LLC, Registered Agent Holloway Administrative Services, filing address 1440 Commerce Boulevard, Suite 312. This address is also listed on campaign finance disclosures filed by Councilwoman Judith Calder as her campaign office address. Exhibit 7. State Ethics Commission Financial Disclosure for Judge Gault, filed January of this year. This disclosure is required to list all business interests, investments, and income sources exceeding $1,000. A limited partnership called Meridian Holdings Group is not listed. However, Secretary of State records show Meridian Holdings Group was incorporated 14 months ago, and its filing address matches that of Cornerstone Meridian LLC. The gallery was silent. Not the silence of boredom, the silence of an audience that has stopped breathing. Lathrop stood. Objection. This testimony exceeds the scope of the complaint. Ms. Redmond is alleging a conspiracy involving entities and individuals who are not parties to this proceeding and who have not been given an opportunity to respond. Sloan looked at Lathrop over his reading glasses. This is a conduct review, Counselor, not a trial. The rules of evidence are relaxed. The Commission will consider the weight and relevance of all testimony. Your objection is noted. Please continue, Ms. Redmond. Lathrop sat, but she didn't fold. She was waiting. Sharice could see it, the coiled patience of a litigator who has one card left and is choosing the precise moment to play it. Sharice continued through Exhibits 8 through 14, body cam footage from Trent Kimball's vest camera, obtained through a public records request, showing the two enforcement encounters. She didn't play the video. She read the timestamps and described the conduct, because this was a transcript-based proceeding, and every word she spoke would be part of the official record. Body cam footage, date June 14th, timestamp 0614 hours. Officer Kimball makes initial physical contact with the occupant, me, by grabbing my right forearm and pulling me toward the door. I am wearing a bathrobe. I am holding a mug of tea. I have not resisted, threatened, or obstructed the officer in any way. Body cam footage, date June 21st, timestamp 0652 hours. Officer Kimball seizes my right wrist during a property removal. I am reaching for a box containing personal correspondence. I am compliant. I have asked him to release me. He maintains the grip for approximately 3 seconds. She held up her phone. A photograph of her wrist, taken June 22nd. 4 finger-shaped bruises, dark against dark skin, visible and documented. Your Honor, I have one additional exhibit. Sloan nodded. Exhibit 15. Exhibit. Audio recording from my personal recording device, June 21st, 7:26 a.m. This is the voice of Enforcement Officer Trent Kimball speaking to his partner, Officer Pruitt, as they exit my residence. I will read the transcription. She opened her notebook to the page. The recording captures Officer Kimball saying, and I am quoting from the authenticated transcript, "Another one down. Ogden said Lathrop wants the Sycamore Street batch filed by the 15th. Tell him the Pickett property closed yesterday. Easy money." The silence in the gallery became something else. Not silence, but vacuum. The absence of sound that happens when 173 people simultaneously stop shifting, stop whispering, stop existing as anything other than witnesses. Gault's attorney put his hand on Gault's arm. Gault was staring at the table. His mouth was open, no sound coming out. Paige Lathrop rose. Your Honor. Her voice was controlled, but the control was visible now, a structure under strain. I moved to strike the audio recording. It was obtained without the knowledge or consent of the recorded parties. This state is a two-party consent state under Statute Section 512.012. Any recording made without the consent of all parties is inadmissible and constitutes a criminal violation. The courtroom waited. Sharice answered before Sloan could rule. Section 512.012 contains an exception. Subsection C permits one-party recording when the recording party has reasonable belief that the recorded communication constitutes evidence of a criminal act. The conversation I recorded references coordination between a court clerk, a law firm, and an enforcement officer to expedite eviction proceedings for financial benefit. That constitutes potential evidence of fraud, conspiracy, and deprivation of civil rights under 18 U.S.C. Section 242. She said this without looking at her notes. Lathrop stared at her, then smiled. Not the predatory smile from the courtroom. A different smile. The smile of a chess player who has just been checked and knows it, and who has one move left. Your Honor, I have a preliminary matter to raise before the Commission considers the admissibility of this recording. Proceed. Ms. Redmond has disclosed that she is a former Assistant Attorney General with 15 years of prosecutorial experience. She has also testified that she began investigating the pattern she describes 14 months ago, 6 months before her own eviction. She purchased her property in the 4th District 7 years ago, moved from another state, and by her own testimony began systematically documenting court proceedings and filing public records requests more than a year before she was personally affected. Lathrop paused. Let the implication build. The implication is clear. Ms. Redmond did not stumble upon this pattern as a concerned homeowner. She identified it, tracked it, and chose to remain in its path. She could have sold her property and left at any time. She could have reported her findings to law enforcement without becoming a litigant. Instead, she allowed the eviction to proceed, became a victim by choice, to generate standing, to create a sympathetic narrative, and to deploy her prosecutorial training in a proceeding where she would appear to be an ordinary citizen fighting a powerful system. She looked at the gallery, at the homeowners, at the reporters. Ms. Redmond is not a victim. She is an operative, and this commission should consider whether her testimony reflects genuine harm or manufactured evidence. The gallery erupted. Voices, movement. Marvina Pickett stood up. Langston Bryce was shaking his head. Calvin Trask gripped his legal pad so tightly it bent. Sloan gavelled once, twice. Order returned slowly. Sharice waited until the room was quiet. Then she spoke. Councillor Lathrop is asking this commission to believe that I bought a house, lived in it for 7 years, planted a garden, made friends with my neighbors, brought soup to a 74-year-old woman recovering from hip surgery, and waited patiently for a corrupt system to steal my home, all as part of a scheme to generate a legal case. She paused. With respect, if I wanted to build a case against Judge Gault, I would not have needed to lose my house to do it. I would have filed a complaint from my desk using the same public records I've presented today without ever appearing in this courtroom. The reason I'm here, the reason I'm sitting in this chair instead of behind it, is that I didn't want to be a prosecutor anymore. I wanted to be a neighbor, and my neighbors are losing their homes. She looked at Oralee Pickett's daughter, at Langston Bryce, at Dinah Falk, who had taken another personal day from the hospital to sit in a courtroom 60 miles from home and watch someone fight for a right she'd already lost. I didn't choose to be a victim. I chose to be a homeowner. The system made me a victim, and my professional background doesn't change what the system did. It just means I know how to prove it. Sloan removed his glasses, rubbed his eyes, put them back on. The commission will take a 30-minute recess to review the submitted evidence. Both parties will have an opportunity to make closing statements when we reconvene. He rose. The room broke into motion, reporters on phones, attorneys huddling, homeowners talking in low voices, the particular energy of a space where something has shifted and nobody is sure yet what shape it will take when it settles. Calvin Trask found Sharice at the water fountain in the hallway. That was... He stopped. Started again. Ms. Redmond, I've been calling you that for 3 months. I didn't know why it felt different. I thought it was just respect for someone who knew more than I did. But it wasn't that. What was it? Recognition. I didn't know what I was recognizing, but something in the way you spoke, the way you organized your arguments, the way you treated every document like it was a piece of evidence in a case that mattered. I could tell you'd done this before, that this wasn't your first time in a fight like this. Sharice drank from the fountain, wiped her mouth. It's not my first fight, she said, but it's the most personal. Does it get easier? She looked at him. 29 years old, 87 cases, student loans he couldn't pay, fighting a system that was designed to exhaust people like him before they could change it. No, she said, it doesn't get easier. It gets clearer. You learn to see what matters and what's noise. But easier? No. The day it feels easy is the day you've stopped paying attention. The commission reconvened. Sloan read his preliminary findings. Judge Harlan Gault was suspended from the bench pending a full investigation by the Judicial Conduct Commission. The suspension was administrative, not punitive, a distinction that meant Gault kept his salary and benefits while the investigation proceeded. He was prohibited from hearing any cases, signing any orders, or entering the 14th District Courthouse. The commission referred the matter of Niles Ogden's filing date alterations to the District Attorney's Office for potential criminal investigation. Obstruction of justice, tampering with court records, charges that carried up to 5 years if prosecuted, but that would take months to investigate and might end in a plea deal or a quiet dismissal. The commission recommended that the State Attorney General's Office open a formal civil rights investigation into eviction practices in the 4th District, with specific attention to the relationship between Cornerstone Meridian LLC, Graymark, and Lathrop LLP, and the judicial appointment process. The commission did not order Gault's removal, did not disbar Paige Lathrop, did not void the 214 eviction orders, did not return a single house to a single homeowner. What it did was open doors. Slowly, procedurally, with the grinding patience of a system that moves at the speed of bureaucracy, because bureaucracy is the speed at which accountability travels when power doesn't want to be held accountable. Gault's attorney issued a statement. Judge Gault looks forward to cooperating fully with the investigation and is confident that the review will demonstrate his consistent adherence to judicial standards. Paige Lathrop left the courthouse without speaking to reporters. Her litigation partner issued a written statement. Ms. Lathrop categorically denies any wrongdoing and will vigorously defend her professional record. Councilwoman Judith Calder issued no statement at all. 2 weeks later, late August. Sharice was still living in Marvina's apartment. Her house was still owned by Cornerstone Meridian LLC. The padlock was still on the door. The garden she'd planted was beginning to brown in the summer heat, untended. But things had shifted. Not resolved, shifted. The way tectonic plates shift. Slowly, invisibly, with consequences that take years to manifest. The state AG's office opened the investigation. Dana Cavil was assigned as lead. She had a team of 4 attorneys, a forensic accountant, and a budget that would last 6 months, after which, if results were insufficient, the investigation would be reassessed, which was bureaucratic language for quietly closed. Soleil Damas published a second article. This one focused on Cornerstone Meridian's property portfolio, 47 houses in the 4th District, all acquired through eviction sales, total purchase price $2.8 million, total assessed value $11.3 million. An $8.5 million gap between what was paid and what the properties were worth. The article used the phrase systematic wealth extraction from black communities, and 3 national outlets picked it up. Trent Kimball's administrative leave was extended. The Internal Review of Enforcement Procedures recommended additional training on occupant interaction protocols. No discipline, no termination. Training, the system's antibiotic of choice. Not enough to cure the infection, just enough to make it look like treatment. Langston Bryce's house was returned to him. Not through the courts, through a voluntary property reversion initiated by Cornerstone Meridian LLC, which suddenly discovered a title irregularity that required the transfer to be reversed. No admission of wrongdoing. No compensation for the 6 weeks Bryce had spent sleeping on his sister's couch. Orly Pickett's house was not returned. Cornerstone Meridian had already begun renovation. New siding, new windows, a for rent sign at a price 3 times what Orly had paid in monthly taxes. Marvina was pursuing an appeal, but the appeal required a hearing before a judge, and the only judges available in the 14th District were Gault's colleagues, who had watched the proceedings and were now treating every eviction case like a potential landmine. Dinah Falk received a letter from the county storage facility. Her belongings, everything she owned, had been disposed of pursuant to the 30-day hold policy. The hold had expired while she was recovering from surgery and did not know which facility held her possessions. 30 years of a life, cataloged as unclaimed and sent to a landfill. She called Sharice. She didn't cry, she didn't shout. She said very quietly, "They threw away my mother's quilt." Sharice sat with those words for a long time. September 3rd. Sharice met Eunice Rowe at Bramwell's, the same restaurant where, according to the receipt records, Judge Gault and Paige Lathrop had shared 23 lunches in 18 months. Sharice had chosen it deliberately. She wanted to sit in the space where the arrangement had been maintained, where the deals had been implied over appetizers and confirmed over coffee, where the machine's social lubrication had been applied with regularity and discretion. Eunice ordered tea. Sharice ordered water. "You did something," Eunice said. "I'm not sure you did enough." "I know." Gault is suspended but not removed. Lathrop is under review but still practicing. Calder hasn't been touched. Ogden retired before anyone could subpoena him. And 156 homeowners are still displaced. 155. Bryce got his house back. 1 out of 157. Sharice turned her water glass on the table. Condensation left a ring on the wood. Dark, circular, the kind of mark that looks permanent until you wipe it away. The AG investigation will take 18 months minimum. The JCC review will take 12. If the DA charges Ogden, the trial won't start until next spring. If the DOJ gets involved, and Cavil has indicated she's making a federal referral under the Fair Housing Act, that's a 3 to 5 year process. And in the meantime? In the meantime, the machine is paused, not stopped, paused. No new evictions have been filed by Graymark and Lathrop since the article. Gault's cases have been reassigned to 3 different judges, all of whom are now reviewing every default judgment on the docket. The county recorder has flagged all Cornerstone Meridian transactions for title review. Paused isn't victory. No, but paused is something the machine hasn't experienced before. And sometimes a pause is how a machine starts to break, not with a dramatic failure, but with a slow loss of momentum that compounds over time. Eunice studied her. You sound like a woman who's done this before. I have, twice. Both times the investigation took years. Both times the outcome was partial. Some people held accountable, some people transferred, some people retired with pensions they didn't deserve. Both times the policy changed for 18 months and then reverted. Then why do it? Sharice looked out the window. The street outside Bramwell's was lined with trees whose leaves were beginning to turn. Early September gold, the first suggestion of a season that would strip everything bare and start again. Because Oralee Pickett lived in her house for 42 years. Because Dinah Falk's mother made a quilt that's in a landfill. Because Langston Bryce saved for 9 years to buy his first home and almost lost it in 15 minutes. Because the system doesn't stop unless someone makes it inconvenient to continue, and inconvenience is the only language bureaucracy understands. She finished her water. I can't get Oralee's house back. I probably can't get mine back either. Not for months, maybe years. But I can make it harder for the next 214 to happen. And if that's all this was, if the only thing I accomplished in 14 months is making it harder, then it was worth it. Eunice nodded. Not agreement. Acknowledgement. The nod of a woman who had spent 30 years watching justice arrive late, incomplete, and exhausting, and had never stopped believing it was worth the wait. One more thing, Eunice said. She reached into her bag, pulled out an envelope, slid it across the table. This arrived at my house yesterday. No return address, no postmark, hand-delivered. Sharice opened the envelope. Inside, a single sheet of paper. A list of 6 addresses. She recognized 2 immediately, Oralee Pickett's house on Wisteria Ridge and Langston Bryce's house on Oleander Street. 4 addresses she had never seen before. Different streets, different neighborhoods, all in the 4th District. She turned the paper over. On the back, in the same red ink she had seen before, the same blocky handwriting, the same ballpoint pressure, 2 words, Phase 3. She stared at it. The restaurant noise faded. The September light through the window went flat. Phase 3. The machine wasn't paused. It had simply moved to addresses she hadn't mapped yet. While she was testifying, while the JCC was reviewing, while the AG was investigating and the reporters were reporting and the system was performing the theater of accountability it performed so well, the machine had kept running, quietly, on streets she hadn't walked, in homes she hadn't visited, against people she hadn't met. 214 was not the number. 214 was just what she'd found. She looked at Eunice. I need a phone. You have a phone. I need a different phone, one that isn't compromised. Eunice didn't ask. She reached into her bag, pulled out a prepaid cell, the kind bought at a drugstore with cash, the kind that people in Sharice's former profession called a burn phone, and placed it on the table. Sharice dialed a number from memory, a number she hadn't called in 7 years, a number that belonged to a woman in a federal office building in Washington, D.C., who had once told Sharice, "If you ever find something too big for one state, you call me, day or night." The phone rang 3 times. Civil Rights Division. This is Sharice Redmond. I need to speak with Deputy Assistant Attorney General Lowell. Tell her it's about a pattern or practice case. Tell her it's housing. Tell her it's... She looked at the list. 6 addresses. Phase 3. A machine that hadn't stopped, had just gone quiet, had learned from its exposure and adjusted its operations the way any organism adjusts when it encounters resistance, by moving to where the resistance isn't. Tell her it's bigger than I thought. Chad. That night, Sharice sat alone in Marvina's apartment. Marvina was in Philadelphia visiting Aurelie, who was still in the nursing facility, still asking when she could go home. The apartment was quiet. The kind of quiet that fills a space when the person who usually occupies it is absent, and the person who remains is not quite a guest and not quite a resident, but something in between. A woman living in the gap between what she lost and what she hasn't yet recovered. Her phone, her real phone, not the burn phone, buzzed. A text from Calvin Trask. Ms. Redmond. The AG's office confirmed they're issuing subpoenas for Cornerstone Meridian's financial records next week. Cavill says your testimony was the strongest evidence package she's seen in 4 years. She also said to tell you, and I'm quoting, "The Georgetown Law Alumni Network is smaller than people think." Sharice read it twice, allowed herself a small, tired smile. Then another text. From Soleil Damas. Follow-up article runs tomorrow. Front page. Calder's campaign office refused comment, but I found something in the rezoning records. The Phase 2 properties are already on the development timeline. Call me in the morning. Phase 2. The properties already acquired, already being converted, already generating returns for investors whose names were hidden behind LLCs, that were hidden behind registered agents, that were hidden behind filing addresses that led, eventually, to a councilwoman's campaign office. And now, Phase 3. New addresses, new targets, new homeowners who didn't know yet that the machine had their street numbers in a file and their eviction dates on a calendar. Sharice opened her notebook, turned to a fresh page, wrote the date, September 3rd. Then she wrote 6 addresses, the ones from the paper, the Phase 3 targets. Below them she wrote, 4 addresses unidentified, need homeowner names, need property records, need tax status, need to determine if assessments have already been fabricated. Below that, timeline, a G subpoenas next week. JCC review ongoing. DOJ referral in process. Estimate 6 to 18 months before federal action. Below that, the machine is still running. Paused is not stopped. She closed the notebook, set down the pen, looked at the wall of Marvina's kitchen, a wall decorated with photographs of Aurelie's grandchildren, of family barbecues, of a life that had been assembled piece by piece over 7 decades and disassembled in 90 seconds by a judge who didn't read what he signed. Sharice Redmond had spent 15 years as a prosecutor and 7 years trying to stop being one. She had bought a house and planted a garden and learned the names of her neighbors' dogs. She had carried soup across the street and sorted recycling into 4 bins and sat on her back porch in the particular silence of a woman who had earned the right to be still. And then the machine came for her street, and she discovered that the thing she was running from was the thing she was built for. She picked up the burn phone. "Burn," dialed Cavill. "The addresses I gave you. Have your team run them against the court docket for new filings. If Cornerstone Meridian has started the process for Phase 3, we might still be ahead of the curve. If the assessments are already in the system, Ms. Redmond, it's 11:30 at night. I know what time it is." A pause, then, "I'll run them first thing in the morning." "Thank you." She hung up, set the phone on the table, looked at it for a long time. Somewhere in the 4th District, in a house she hadn't visited on a street she hadn't mapped, a homeowner was sleeping in a bed they owned, in a room they'd painted, under a roof they'd paid for, unaware that a machine made of paperwork and procedures and a judge's signature was already calculating how to take it from them. Sharice couldn't stop the machine tonight, but she could make sure it knew she was watching. She opened her laptop, pulled up the court's electronic filing system, typed in the first of the 4 unknown addresses. A filing appeared, dated August 29th, 5 days ago. Cornerstone Meridian LLC. Municipal assessment. Filed by, she leaned closer, not Graymark and Lathrop. A different firm, a name she didn't recognize. They had changed attorneys, changed the firm name on the filings, kept the same plaintiff, the same scheme, the same judge, Except Gault was suspended now, so the filing was assigned to a different judge, one whose calendar Sharice hadn't yet studied, whose patterns she hadn't yet mapped, whose relationship to the machine she hadn't yet documented. A new front, a new name. The same machine. She began a new spreadsheet. Row 1. Address, filing date, plaintiff, attorney, assigned judge. Homeowner name, unknown. She would find the name tomorrow, and the next name, and the next, because that was the work, not the dramatic courtroom moments, not the receipts read into the record, not the headlines or the investigations or the commissions. The work was this: a woman at a kitchen table at midnight, typing addresses into a search bar, building a map of something that didn't want to be mapped, refusing to stop because stopping meant the machine won, and the machine winning meant another Aurelie Pickett losing a home she'd lived in for 42 years, another Dinah Falk losing her mother's quilt, another Langston Bryce crying in a courthouse hallway because the system he trusted had been designed to betray him. Sharice Redmond had tried to stop fighting. The world hadn't let her. So she kept going. Not because she believed the system would change overnight, not because she expected justice to arrive complete and satisfying and wrapped in a resolution that tied up every thread, but because the alternative, silence, withdrawal, the quiet surrender of a woman who knows better but decides it's someone else's problem, was something she could not live with. The laptop screen glowed in the dark apartment. Outside, the September night was warm and still and full of the sounds of a neighborhood that didn't know it was under siege. Inside, Sharice Redmond worked, one address at a time, one name at a time, one document at a time. The way change happens, slowly, painfully, through the accumulated weight of evidence that refuses to be ignored, through a woman who refused to quit, even when the judge laughed, especially when the judge laughed.
Thank you for taking the time to watch this video today. If you found the content helpful, please remember to like and subscribe so you won't miss our upcoming episodes. If you have any questions or suggestions, feel free to leave a comment below. We are always here to listen.